Yes.
My lord, one petitioner is a lady government servant, my lord. Challenging the criminal proceeding, my lord. Trial court fixed the date for 29th February, my lord. Petitioner is a government lady, sir. And I am challenging the criminal proceeding.
What happened?
Criminal proceeding, my lord. Yeah, because of his her husband involved in a criminal case, my lord. Her name has also been included in this case, my lord. 354-506 offense, my lord.
Now, what do you want?
Criminal proceeding, my lord. I have challenged.
Passing.
Yes, my lord.
Take it.
Day after tomorrow.
No, day after tomorrow we'll have to see.
Yes, my lord. Otherwise, you are
tomorrow is not possible.
28.
Day after tomorrow will be virtually half day.
Sorry, man. 27. 28 has been dead fixed for appearance.
Just see how can you.
Item 38 of the today list permitted to withdraw.
Withdraw. Memo
To phrase 482 material. Item to phrase 482 material. Yes, ma'am.
Memo you give priority by.
My lord, item 71. May I pray for 1 week after, my lord?
After notice,
Your lordship directed to appear before the police. Most of the petition appear
after notice or fresh matter?
after notice, my lord.
The other side?
No, this question matter, my lord, I will inform, my lord.
No, inform. I'll note it down. When it will come, we will adjourn. Okay. You may not come. No problem. You have a petitioner?
I have already informed, my lord.
But I'll adjourn it when the matter is called for. You may not come. I'll inform.
Item 637. Item 3 fresh admission. Pray for 1 week after.
70?
Item 3.
3.
Fresh admission.
3 will come within 3 seconds.
Why
are you not? Anyway, 3 adjourned.
Item 67. Compromise matter, your lordship directed to appear before. Due to rain, they could not come, my lord. Lordship keep it to 9th or 10th April.
But 2 o'clock there won't be any rain.
10th or 9th or 10th. Yeah. Oblige.
Pardon to make a mention, your lordship. IA number 3655 of 2023, stay of further proceeding of a criminal miscase.
What the main petition is?
CRLMC 978 of 2023.
What is that?
Execution case of.
You are not sure what is the case.
A bit unsure.
Read and come at 2 o'clock mention. Okay.
Your lordship.
Read the entire file. Come and mention. I'll allow. No problem.
Obliged.
Beg pardon, your lordship. I want to mention a 482 matter, your lordship. Previously, your lordship directed that this matter.
Yes.
Beg pardon. Your lordship directed that one matter may be listed on 20th of March 2024, my lord. But now in the list, my lord, the matter is not listed, your lordship. Yesterday also.
Was there any direction for today?
In the last occasion, I mentioned before this honorable court that another matter, that is CRLMC number 4818 of 2023, where senior advocate Debasis Pondas are arguing that matter. That matter and my matter are similar, my lord. For that reason,
I don't know 12, my lord. That my lord 1687 provider or NDP.
That matter is listed on today.
Listed for today, your lordship. But my matter not listed even after the mention, my lord.
We'll see if they will get benefit. If I allow, then mention tomorrow. If I am dismissing, you need not mention.
My lord,
mention it tomorrow. Wait till 12. Item 12. Mention it tomorrow. We'll see. Okay. Mention it tomorrow. Okay.
Again, one request, your lordship. Even after the specific mention date, the matters are not listed, your lordship.
See, there are many problems in the listing. Because
the specific date, my lord, the matter may be listed tomorrow. The matters are not listed.
Specific date matter. Huh? And you give the case number, we'll see.
Grateful, your lordship.
Yes. I beg your pardon, my lord. My lord, item 53. May I audible, my lord?
Yes, yes.
Item 53, my lord, after notice matter, there is a noting that the notice was returned back as the opposite party, my lord, not staying in the permanent address. So I'll furnish a new address within 3 days, my lord, because he is a government. my lord.
53, 53.
53, my lord. Item 53.
Your Lordship, may I be pardoned to make a mention in item 58, Your Lordship?
Yes.
Your Lordship, item 58 on behalf of Mr. Sarthak Naik, I'm praying for some time to file the counter, Your Lordship. We have not yet received
No,
instructions.
who is for petitioner?
Malad, I am for the petitioner.
Yes.
We had filed an application because there was a condition that, my lords, we have to surrender a passport. And my lords, while traveling, again, we have to ask for permission. I had only sought waiver for that surrender of passport because, my lords, he has offices in Bangladesh, Dubai, because he is a big producer of movies, my lords. So now, my lords, they may take time for filing a counter. I pray it come up on 27th or 28th, any date, my lords.
Your Lordship, may I pray that the matter be fixed on 4th?
My lords, the problem is, my lords,
humble
he has
prayer.
his opening in Bangladesh, opening of his offices in the first week of April. He has to go forth and back.
Then,
And
as Your Lordship
And
pleases.
yes,
Let it be second then, 2nd April.
as your lordship please.
As Your Lordship
For
pleases.
27th or 28th, as your lordship please.
As Your Lordship
But
pleases.
we are not sure about 27, 28.
Mal.
In between, I don't know. So therefore, let it be second.
As your lordship.
As Your Lordship
Second.
pleases.
Item,
I'm much obliged, Your Lordship.
item 53, there is an interim order, Your Lordship may extend.
Yes, interim order will continue.
I mean, pardon to mention.
Yes.
One modification, BLAPL 1302 of 2024, my lord, in place of Khorda, the inner battle type as Keonjhar, my lord, for which I have filed an IA for modification, my lord.
What you had written in the petition? Khurda or
Yes, Khorda, my lord.
Khurda?
Yes,
Bail granted.
yes, my lord.
Can it be listed at 2 o'clock? We have granted bail because of mistake in
Yes.
there. All tomorrow.
Yes.
Tomorrow. Take it tomorrow.
And another thing, my lord, and subject to verification antecedent was given in respect of.
All these things don't tell you.
Okay.
Only correction I'll do.
Yes, ma'am.
May I seek your lordship?
Yes.
Yes.
May I seek your lordship permission to mention a matter, my lord, says criminal MC number 3696. Your lordship had directed this matter to be, had referred it to mediation and had directed this matter to be listed on 20th of March 2024. But despite our best effort, my lord, the other side are not ready and the mediation report has been sent to your lordships also. So now, my lord, I'm only praying for a date for argument, my lord, since mediation is filled and despite our best efforts, my lord.
There is no report as such.
No, the report, my lord, they informed our client that they'll be sending. Yesterday only they had said it may reach your lordship by today. So I'm only praying if this can be listed.
Yes, Mr. Singh, the moment we get the mediation report, we'll indicate a date.
So what I was praying your lordship is that once your lordship sees the report, my lord, since it has already failed, so my lord, I was only praying if your lordship can list it on 4th of April for hearing, my lords. I'll be grateful if it's not inconvenient.
Let the report come. You note it down. If the report comes along with the report, please. Okay.
So should I mention it again, my lords?
No, we are noting it down. We'll see. We'll get it listed on that.
So I'm only praying for a date if it's not inconvenient. 4th of April, my lords.
That's what I'm saying.
I'm so grateful. I'm so grateful. Deeply obliged.
I may be pardoned to make a mention, your lordship. Item 16 of today's list. It is a part-heard matter. In fact, on the last occasion, senior advocate Mr. Dhal was appearing. He is not available today.
Part-heard matter.
Part-heard, but no stay order is there.
But where is the other side?
No, state is the other side, my lord. 1 week after, in first week of April, any day, your lordship. Obliged, your lordship.
I beg your pardon, your lordship. Yesterday, your lordship was about to dispose of a matter. Only the petitioner was not.
Yes.
It is listed as item 65, and the petitioner is here.
Okay. Please. 65. Take it up. 65 last order pass करते ना 65. 65. ये आसन होते हुए मैं इसका कोई एडजस्ट कर दूँगा. ठीक है? बोलता शी is come. The matter was listed for hearing on 19/3/2023, 24. This court has passed the following order. Pursuant to the aforementioned order, the petitioner is appearing in person. He has also filed his self-attested copies of Aadhaar cards to establish his identity, which is taken on record. He submits that the matter has already been settled. And the opposite party number 2 has filed an affidavit before this court to that effect. The authenticity of the affidavit filed by opposite party number 2 has already been verified through the IIC Anandapur. The written instruction has already been placed on record
So also the
by Mr. Ragada.
and so also the applications given by the
That I can't order reproduce in the fact scenario of the present case, Mr. Ragada submits that this court can give indulgence to pass the FIR as the parties have settled their dispute, taking into consideration the aforementioned fact, the circumstances, the FIR number so and so, and consequential proceeding, quasi petitioners are quasi.
Your Lordship, pardon to mention, Your Lordship, I'm extremely sorry. I know Your Lordship doesn't like mentioning in between. Your Lordships, due to this network distortion, I could not join. Lordships, in that matter, on 2nd, my brother is getting engaged. On that day, we have the function. Any date after 4th. And he told me over telephone also, Mr. Kanungo, that I'm ready for 4th, and he's now objecting behind my back. I spoke to him and mentioned.
Mr. Kanungo says that the 4th he has a problem.
Any date, Your Lordship.
You sort it out amongst yourself and tell me what to do.
Your Lordship, any date after 4th.
You tell the office of Mr. Kanungo and we will list it on 4th. Okay.
Okay, Your Lordships. Yes.
Because he has brother's engagement. 50. 4th.
Oblige, Your Lordships.
Yes.
May I please, Lordship? My application order section 457 CRPC was rejected by the learned courts below. Against that, I have preferred this present CLMC application on the ground that the investigation was pending and the articles which are seized are required for TI period. So TI period not conducted, so my application was rejected. So in
where is that order?
Order is at page 24, my lord.
24.
Yes, my lord.
Okay.
The investigation of the case is pending, and the alleged gold amounts are seized in this case. Allegation of stolen articles.
Which paragraph you are reading?
Page 24.
Yes.
So 5 para.
In this case, it is alleged by the prosecution that on report of so regarding the theft of the gold and
Next para, my lord. So para.
Case is pending. The alleged gold ornaments were seized by the so TI period. How can it be released?
Let now.
Instruction not with me whether the investigation is completed not valid, that is not.
And on the pretext of TI period to be conducted.
Valid.
It was not granted.
The first time listed is also.
Issue notice. CD. Let him fix the fact. If TI period and everything is over, then you can verify. Or shall I dispose it up and say that
it will better.
I shall file a fresh application for the learned court below.
That's right. Write down. The petitioner moved an application under 457
Yes,
CRPC seeking release of the gold ornament which was seized from his custody during the investigation.
Yes.
The learned Sessions Court, which Sessions Court?
Additional Sessions Judge.
Learned Third Additional Sessions Judge, Special Judge, Vigilance, wide order dated 13/6/2022 in Criminal Revision 33 of 2022 has rejected the application only on the ground that investigation is still going on, and the seized articles may be put to TI period.
While confirming the order dated 2/4/2022 passed by
Maybe
the
put to TI period. The said order was passed by confirming the order of learned
SDGM Bhubaneswar.
SDGM Bhubaneswar.
Order dated 2
Then council for the SDGM position dated
Bhubaneswar order dated 2/4/2022 passed in CMC number 262 of 2021.
Then council the petitioner submits that the investigation has already been completed, and the ground on which the application was rejected is no more available to the prosecution. In view of the subsequent development which has taken place in the present case, the petitioner may move a fresh application before the court below, under section 457 CRPC. If such application is moved, the same shall be disposed of within a month on its own merit, on its own disposal. Move application within 1 month.
May I please also? Present petition is a laborer. The offense under section 3761 and 366/506. There is some relation to last 5 years. Now the proceeding is pending before the STGM, and the apprehension for arrest, that is I came from quashing of that proceeding as well as FIR. First, you kind of glance to the FIR at page 13. That is bulky FIR. There is no material available against the present petitioner.
376.
My lord.
What is the stage of investigation?
Investigation is going on, but in fact, the prayer for anticipated application has been
Rejected. Therefore, he files it.
For that reason. And there are the allegations, my lord.
Then it is a appeal by disguise against the order of the rejection of bail.
Clearly well stated about the
May I pray, now the warrant is kindly issue. That is why I filed 482 application.
Then where is the warrant?
No investigation going on, but the proceeding is continuing in the trial court. That is why
what to do? You have applied for ABPL. Where is that order?
Annex 2, my lord. Annex
23.
Page 22. Page 22, my lord. Is a laborer. Last petition age 52 and victim age 42.
Laborer doesn't mean
that is some with consent. That is why.
Do you have? Can I sabotage the order of the coordinated bench by passing another order?
No.
There is an order already rejecting your anticipatory bail. If I give any kind of protection to you, that is tantamounting to sabotaging.
I came for quashing of the criminal proceeding.
Quashing is not possible. Investigation is still on. Quashing is not possible.
76
and you have got an order by the coordinate bench rejecting your application. What can it be?
I will surrender and
do. You tell me if NBW is issued also, I could have said anything.
NBW no.
Messages are going on.
Nothing can be done. No, hands are tied. Nothing can be done.
Let them surrender. Go on bail for time being. Surrender कर bail जाओ देखिए आगे कारण ये लोकटर.
Can I do it in the face of the order passed by the coordinate bench?
No.
Your application under 438 is rejected.
No. Yes.
If I pass the order, then
I press stay of the GR case. That
how can I stay? Investigation is going on. There should be some.
Charge sheet not yet filed.
Merely because your anticipatory bail is rejected, you can't ask for quashing of the entire thing. Right. The petitioner seeks to withdraw the present petition to pursue his remedy available under law by surrendering before the court below. he may do so, he may do so within 15 days, within 15 days, no, on or before 5th of April, 5th of April, with this liberty petition disposed of. What to do? I don't understand in this situation.
One password.
Password.
One password after lunch hearing rules. And let it go next week. Let it come, let him come.
After fresh this thing I can call. After immediately call. Huh? Yes. After 5. No. Fresh matter. Anyway, next 5.
5, let's say prefer an adjournment.
Adjournment. Adjourn.
Item 6.
Adjourn.
Item 7.
Praise the Lord.
Yes.
Here, my lord, petitioner challenge quashing of proceeding, my lord. Here, my lord, at the time of occurrence, petitioner is a juvenile, my lord. I have annexed the certificate, school certificate, and now is a student. Annexed 2, my lord. But charge sheet has been filed against the petitioner without sending the to juvenile justice board record, my lord.
What are the remedies?
So, my lord, the record should be transmitted. I will appear before the juvenile justice board.
You have to move the application there before the court below that
No,
stating all the filing, all these things,
What is the
this
remedy?
equivalent,
482.
the competent,
You have to tell to that court,
my lord.
that I am a juvenile. Please
Because
don't try.
That court satisfied, then send it to my lord.
No, your lordship, they have charge sheet. They have admitted the page. I have annexed 13.
Why
Your
can't you go there? I am giving you
Your
liberty.
Your lordship, because I am not in bail,
This court giving liberty, go there
and protection, your lordship, I will.
There should be some semblance of law somewhere.
Your lordship, kindly see.
That court is not giving, so therefore I'll come to this court and makes
only my lord anticipated application rejected.
Rejected. I know that.
Is it pay?
So therefore you file a 480.
Because 13.
Forget about the law procedure and all. I am giving you a liberty.
Yes, ma'am.
Go to that court and say that I am a juvenile.
Yes.
Please don't try. Send it to the juvenile court. Then he will look into the authenticity of your document, conduct an inquiry. If he found that you are a juvenile, he'll send it to. That is the procedure. I can't conduct an inquiry here.
Yes.
Under 482.
Page 28, they have admitted 13 years.
Maybe admitted.
Yes, ma'am.
Maybe admitted.
And I have, yes.
But the court has to apply the mind.
And your lordship, so but till that tell give some protection because I am a juvenile student, Einstein diploma student.
If your anticipatory bail application would not have been rejected, I would have done it. But because I can't supersede the order, or I can't appeal over the order of our court.
Because I am a student, other person had been released on bail. Lordship observe that also other co-accused person has also been released on bail.
Right on the petitioner challenge. And the petitioner is seeking quashing of the entire criminal prosecution in Balugaon PS case number 151 of 2022, corresponding to GR case number 315 of 2022, which is pending before the JMFC Chilka. Next. Then counsel the petitioner submits that admittedly the petitioner is a juvenile at the time of commission of the offense. This fact is germinating from the charge sheet itself. He has also filed various documents to bring home his case regarding the juvenility. juvenile. Juvenile. The proper course, the proper course, the proper course for the petitioner is to apply to the court below regarding the benefit benefit of juvenility, juvenile. But he submits the learned counsel for the petitioner submits that although all the co-accused persons have already been enlarged on bail,
Anticipatory bail.
his anticipatory bail application has been turned down, despite the fact that he is admittedly a juvenile, despite the fact that the prosecution has admitted that he is a juvenile. He seeks to withdraw the present petition to pursue his remedy, appropriate remedy under law, with the aforementioned liberty. The petition is disclosed. I made all observations. Utilize that observation. What to do?
And also after sending the record to the juvenile justice, I will approach. See that take signal for. Send I will approach also.
Why can't I do one thing? I pass an acquittal order.
See send approach before the.
How can I control the proceeding of? See, you ask something which is legally permissible. I am ready to give you. Don't ask something which is not permissible at all.
And your lordship may my prayer is right. So lordship, I will move the application for bail before the appropriate authority that will be considered in accordance. Sita take kar. Sita bail part ta khali. No. Eta bail critical bail ta move save part.
Submit that he would be surrendering before the court and move appropriate application for grant of bail as well as grant of the bail on the ground that he is a juvenile. You establish juvenile, you will get it. Why are you so apprehensive? All the co-accused have already been granted bail, and you, I think you are the main accused.
No, madam, not main. Omnibus.
Then
ମୁଁ ସେଇଠି ଛଡେଇବାକୁ ଯାଇଥିଲି
all probability you will get the relief. Because of your over anxiety only, you moved the application for anticipatory bail and got it rejected.
Yes, I am not the counsel, but
the same thing you are doing here by filing 482. Anyway,
Item 10.
Madam, can I will surrender before the not.
And it turned to.
have you filed it?
Just
filing.
You filed it?
My lords.
Just I received.
My lords, this entire bunch. So, my lords, when the law is clear, then when something is prohibited directly, it is also prohibited indirectly. And when something is directed to be done in a manner, it must be done in that manner or not at all. So, my only case in this is this. I am challenging the order of rejection of my discharge. So, for charging, a prima facie case has to be made out. I am not going into the veracity of the documents. That may be genuine. All the documents may be genuine. But can the court proceed to examine a prima facie a prima facie case can be made out on the basis of?
You say that the entire investigation is vitiated because it is not proceeded in accordance with law.
Exactly, my lords. In accordance with law, this entire bunch, as your lordship, the last direction directed me to obtain this, I have obtained. But my submission is this entire bunch, even though it may be genuine or may bring out prima facie case, but in this case, a complaint case initiated by the DMAT, this document cannot be looked into.
But in the case of 2013, my lord,
Hmm.
2016, my lord, this petitioner or another person filed CRLMC 537 2016 that has been disposed of 4/5/2023, my lord, for non-prosecution. Whether this petitioner or
No, this is a separate petition. The last occasion I've also, my lords, clarified. That petition was challenging the cognizance. Now, this is, my lord, that was
After your application
for
under
discharge have been rejected. I have approached.
some other driver take
Lordship, definitely. This is only my case, my lord.
only answer.
file. You have to file it. Please file it. So that it can be scanned and okay.
Item 11.
My lord, the present petitioner and informant, my lord, are already been compromising themselves, my lord.
Okay.
And the meaning of the filing of this case, my lord, to they wanted to file joint affidavit before the honorable court for compromise.
When are you going to file?
Yes, sir.
Huh? Maybe notice and file. Notice कर देले एक ऐसे पड़े.
If you notice, written first week दे दिया. First week.
My lord, and I have filed a IA, my lord, for
Notice first week I'm giving vacations are going on. Why?
my lord, एबे से continue करছি तଳ कोटे तो
Settlement हेलानी तो कौन problem?
नहीं,
You are the informant.
settlement, but
You are the informant. Nothing.
no, I am the petitioner, my lord.
You say that you are informant in
No.
the court below.
No, I am informant
Then what will happen
in
to
court
you?
below.
You will not be arrested. The petitioner is not coming forward. Why are you worried?
My lord, maybe file for
Why you
time
are
being,
so-
my lord.
I don't understand. You are the
Yes.
complainant.
No, my lord. It's that.
And he said that I am the informant.
Accused, my lord.
Why should you say that hey, I am informant?
Accused number 1.
Accused, my lord.
Rajkit, sir.
Accused number
And
1.
be
my lord.
sure
Sorry,
you are accused or informant. You don't know for whom you are.
accused, my lord. I am petitioner. Sorry,
Only
by
for
mistake.
what I
my lord.
The petitioner is seeking quashing of the FIR, being Nuapada PS case number 97 of 2023, 97 of
Boden,
2013.
Boden PS, my lord. Boden.
Boden case. 2013, what is happening?
They are not cooperating man for that.
What is the stage?
Now, my lord, trial is going on. Man, will be start. Right. Charge has already been framed.
Where is that charge order? And all?
Which
Nothing you have filed. You have to verify whether trial is going on or not. Okay. Issue notice. Mr. Ragada accept notice. Then consequently, the petitioner submits that they have settled the dispute. He has settled the dispute with the complainant. What are the offences?
About 420. my lord.
Settled the dispute with the opposite party number 2. Opposite party number 2. And on the next date of hearing, both the petitioner and opposite party would appear before court and file joint affidavits. Joint affidavit. Tapat likhdo, you know this story. Tapat likhdo in the I recto. Take. Further proceeding in city case number 374 of 13. Pending in the court of JMFC, Boden State. This is the first thing. Fourth. You bring both the parties. Otherwise, I'll vacate the stay.
All right, my lord.
Item 12.
Item 12 will pay for short password.
Password.
Item 13.
Please, lordship. Offence under section 341, 323, 325, 506, 354, my lord. Dispute between two brothers, my lord. I am initially petitioner filed anticipatory bail. It was allowed, but one condition there subject to if injury simple in nature.
But if the allegation 325, one hand is broken. And in the page 7 of the FIR, my lord, there due to civil dispute, Jami Bhagavanta, two brothers between dispute to both the informant is the sister-in-law, my lord, Bhauja, my lord. And only pray, lordship, I will surrender before the court below within 15 days. Till that, I have protected.
Your anticipatory bail application.
Allowed. 7-1, no, allowed, subject to.
Subject to concern,
No,
if
if
there is no
in-
such criminal antecedent you see.
Criminal
But there are
accident-
criminal antecedent you see, for that reason that order that will carry out.
And aggravated offense is also added. Grievous.
That my injury are grievous, sir.
One injury is that hathare
Grievous.
one hand.
Charge sheet is filed.
No investigation procedure.
Investigation going on.
Why are you worried? You are protected. Why are you?
No, I am not
Not
protected.
protected, my lord.
They specific
Mr.
period they have.
If surrender before the court below, and court below it verify the antecedent, if found there are antecedent, there
Where is that order?
That they has quoted, my lord, in paragraph 4, my lord. They mention, mention.
Page 4, madam.
Hmm?
ABLPL 7132.
Page 3, paragraph
You
4
have to
percent.
go to that court to ask for
Modification,
You are
modification.
asking for modification of that order, basically.
It will better.
I'm not asking. Only I
That
pray.
is modification only.
No.
Antecedent pattern is modified.
No, I will appear before the in
You don't understand. You went to that court, you got some order. Now you want some addition in that order or some modification. You go.
No modification, madam. Only I.
This is the modification only. What else you need? Modification of that order.
To consider criminal antecedent, and if the injury is grievous, then
No,
the
that
order
I am
will not be considered.
I am not required that modification that condition also. I am only required to surrender.
You surrender, who stopped you?
Surrender.
Why do you need hand protection again? That's the whole difficulty.
Only
In the face of this
15.
order, how can you do it?
15 days I am not required any change of that. Because injury is
What kind of petitions? I am very surprised. What kind of
Both the
petitions are being
concern-
filed? What kind of interventions are given in 482?
Petitioner.
I haven't seen in my life in this kind of proceeding.
because that time
482s are not meant for
yes
this.
because that time there was
You
a
apply for
there-
anticipatory bail, you are not getting some condition
there,
is
there
hurting
is
you. file in
a
482.
there is a sitting in the house and there is chance of compromise.
Whatever. Compromise, you bring them.
No, that is but subsequently it was not fruitful.
Please understand. You don't file that order also. Give me that order at least. Let me see.
That is
what-
ABLPL 713220.
Give me that order of the
Madam.
coordinate bench dated 11/8/2023.
Well, I mentioned the
You are duty bound to file.
713223.
Huh?
7132 of 20.
That's right, but you are supposed to file that in the court.
I mentioned para 4 but that.
Urgent. Urgent it here.
Passover I will bring.
Next.
Passover I will bring. On Passover.
Passover. Patil. How are you filing this petition? I'm just failed to understand. At least I have never come across this kind of thing in my 32 years of practice. You went to some other court, you got some order. That order you don't file. You are asking modification of that order. Merely because anticipatory bail is rejected, 482 petition is filed. And you don't file that rejection order also. And if some order is passed and it is like virtually concealment only. Can't check everything. Okay, then pass over. Next.
May please last one.
What is?
May please last one.
Yes.
We're challenging the order of execution, my lord, proceeding, my lord.
Execution.
My lord. Maintenance execution.
Huh?
Maintenance case, my lord. 125.
Yes.
That is annexure 1, my lord.
You are the husband.
Yes, my lord.
What was the order?
That is annexure 1, page
How
10.
much? How much?
That is my lord, 1500, my lord, per month, my lord.
Have you challenged this order?
My lord.
No. The maintenance order have you challenged?
Yes, my lord. Maintenance order is passed, my lord, 1500 per month, my lord. That is in the year of 2017, my lord. After we are filed for the criminal revision, my lord. They also subsequently filed for the 127 for the enhancement of the maintenance, my lord.
Right.
Subsequently, the fixed the maintenance is 1500 rupees per month. Yes, my lord, per month. After that, We are also filed for the, they're fixed that key maintenance, area maintenance fixed to 3 years, my lord. Total amount is 45,000, my lord, which is as per section 125 clause 3 and 128. It's a area execution to be 1 year, my lord, 12 months. That's why I'm challenging.
I didn't follow.
My lord, what happened?
I didn't follow the last part. What?
My lord, what
There is
happened?
an entry, there is a maintenance.
Yes, my lord. Maintenance order,
That
my lord.
maintenance order has added finality.
Yes, my lord.
Now execution is filed.
My lord. Execution file 2022, my lord.
Whatever execution
My
is
lord, my
filed.
lord. Yes, my lord.
If the order of maintenance is holding field, you have to comply that order.
Yes, ma'am. We are ready to comply, man. But as per the provision, my lord, that should be 1 year, my lord. 12 months as per the execution proceeding. So total 3 years back only.
Recovery of 3 years.
Yes, my lord. It is counting 3 years, my lord. Total is 45,000.
3 years you don't pay, what will happen? Every year you have to go to jail. That's the
No, yeah, that.
that's the full court judgment of Delhi High Court also.
My lord. That also I'm cited some
Where
judgments.
is that judgment? Show me. Where is that judgment?
That is quoted, my lord,
Hmm.
in page 7, my lord.
7?
Page 7, para 8, my lord.
Okay.
My lord. It is also relevant in the 125 plus 3 and 120 service complementary in nature.
That is relevant to mention.
Yes,
that,
Sri Ravindra Chandra.
120 are complementary in nature. It has been held by the Honorable Court of
Sri Ravindra Chandra Rai.
Ravindra Chandra Rai versus State of Court in OLR. That the section 128 of is supplemented to 125(3) of which provides for enforcement of the order after we satisfied about the identity of the party and non-payment of the mediation law because in so no warrant shall be issued for the recovery of the amount due under this section unless the application made for where is that order?
Order is annexure 1, my lord. And also annexure 2 also revision petition there.
Name is not which part?
That is the page 11, my lord. Past 2, my lord.
Reading.
The claims brought for the contrary of the nature, the same cannot be considered not with the witness due to non-receipt of money having no documented back to emotion. Just a minute. Initially, my lord, kindly page 10, my lord. The middle portion, the claim of making the payment by cash of presence of certain witnesses in case of death, perusal of the evidence record. 45 from 1/9/2019 to 28/3/2023. Middle portion, my lord. The record is starting. The record that is annexure 1, page 10. The record is put up today on strength of the advance petition.
September
10/4. 10/4.
2-3 months only. How much it comes for the 1 year?
That is a 1/9/2019, my lord.
That's right. For 1 year, how much it comes?
Sorry, pardon, my lord.
For 1 year, what is the area for 1 year? You are admittedly you are
15,000.
Your case is
My lord, my lord. 1 year is a 15,000, my lord.
50.
15.
Are you paying that?
Yes, my lord. We are ready to pay, my lord.
Why have you not paid?
They're fixed to 45 to total 3.
Now at least subject to.
Yes, my lord. You will submit
1 year every month 1,500.
500.
How much comes to?
On the choose.
Subject to petitioner depositing 20,000 rupees before the court below to be disbursed to the opposite party number 2, issue notice and in the internagnum proceeding, execution proceeding, execution case proceeding in the execution case, miss case number 8 of 2022 is said till the next date.
Can it be, one year is the
No
12?
negotiation.
My.
Pay 20,000, then only notice will be.
Oh, bless right.
Okay, subject to paper. Yes.
Proceeding with the stay, as for I filed the I for proceeding stay of the execution.
I have stayed the proceeding
Oh, bless.
subject to
They bless, they
20,000 rupees. It has to disburse to the lady.
20,000 rupees.
20,000. Okay. Yes. 15.
May I please, my lords, the petitioner challenges the order of cognizance dated 3/11/2007, my lords, on the ground that the matter has been settled between the parties. Okay, offense under section 498.
Where are they?
Lords,
I am for the informant wife.
Bring
the
them.
complainant is not present. My learned senior appears.
Due to bad weather, she could not come.
All of us came.
Yes.
Despite
Yes, short date may be given so that she will come.
You tell me.
She has
Day after.
no, because she is suffering from asthma. Weather is very cold weather, so she could not come. At least 10 to 15 days is necessary.
Litigants have the luxury of not coming to the court. Lawyers and judges and everybody comes to the court.
She has filed the affidavit.
First week.
Affidavit along with the vocal.
Parties have settled. Notice was issued.
No, my lords.
Parties have
First time
settled.
listed.
This is a matrimonial. The dispute is arising out of a matrimonial discord. Parties have settled their dispute on advance notice. So and so appears and file vocalatama and what has
Affidavit.
and affidavit.
Yes.
Inter alia stating that they have
Settled the matter.
settled their dispute. Since the parties are not present, leave the matter on.
Lords, IA for stay. Lords.
In the interregnum, the proceeding further proceeding
Of GR case number
in GR case number
1493 of 2006.
pending in the court of NCGF
S. Cutter.
Sadar Cutter is stayed.
Grateful. Lords.
First week. Huh? Eight.
8th April.
Bring them on it.
Item
17.
Also.
18.
Can you see the last order, my lord?
Yes.
My lord directed the State Council to obtain the instruction regarding the status of the confiscation proceeding.
Petitioner is agreed by your set. Offset. Offset. Only. Offset को offset कर दिया. Yes.
On a confiscation proceeding already been initiated or is pending, my lord?
I have not received any notice, my lord. I have not received any notice from this since last 2 years. 2022, vehicle has been seized.
Started.
My lord, already started, my lord.
When started?
Notice has
Please.
been issued.
Notice has not been issued.
No, here, my lord, what happened, the confiscation proceeding against the seized vehicle has already been initiated and the seized vehicle is required for the purpose of investigation. Now seized vehicle kept under the custody of a range officer.
You give me the particular concept.
Just
Right on. The application, the petitioner's application under section of 457 CRPC for release of a vehicle, na?
Yes, my lord.
Release of the subject vehicle, although was allowed by the court of JMFC, Cuttack, JMFC 1 Cuttack, by order dated 20th April 2023, but the revisional court has rejected, revisional court has upset. You clear that the order of the court below in the revisional in its revisional jurisdiction. Therefore, the petitioner seeks indulgence. And the last date of hearing, the only ground only ground on which the revisional court has rejected the application is that the confiscation proceeding. Was there any finding? Pending the police bench discourse
Under the page 25, paragraph 7.3.
What is it?
This is a valid report.
Para?
Para 7.3, my lord. It appears by letter dated 1260, dated 15/2/23.
Which page?
25, my lord.
20.
Revisional court order. Already been started on 11/22, and so cause notice have been issued to the owner on 13/12/22. They are there, my lord.
I have not received such.
That confiscation proceeding has already been initiated. The counsel of the petitioner submits that
He has
he
not
has
received.
not received any kind of notice.
File so much.
Notice
To file so
till
much.
date,
Till
till
date.
date regarding the confiscation proceeding. Mr.
But the order shows that notice have been issued.
Mr. Rogda appears for the state on instruction, submits that the confiscation proceeding was initiated, provide confiscation proceeding was initiated, being OR case number 69 capital D of 2022-23. 2023. And assistant conservator of forest has been appointed as an authorized officer on 4/11/2022. The written instruction and the proceeding is still pending. The written instruction received from the authorized officer dated 22/2/2024 is taken on record, and a copy of the same is supplied to the legends office for the petitioner. In view of the aforesaid, it is directed that the authorized officer shall issue a notice to the petitioner insofar as the confiscation proceeding is concerned, and the petitioner is given liberty to participate in the state proceeding. With this observation, the petition is disposed of. You take the copy of part.
Milord, I filed the order for this honorable court last occasion, Milord. During the pendence of the confiscation proceeding,
I have entertained it, and I'm asking you to participate. If your vehicle is released there, it's all right. If it doesn't release, then you come once again. That liberty I'm giving. That's the procedure. I have given the full liberty. You go on. Yes. Yes. Next.
Item 19.
Might be the last. The case of disproportionate asset, Milord. FIR was registered on 6/5/2015. Till now, they have not filed charge sheet against me, Milord.
6/9?
2015, Milord. Till now, they have not filed charge sheet against me. The case is that, Milord, the properties of the present petitioner, also some Stridhana properties of his wife, all are seized, Milord. And particularly the documents relating to immovable properties, which was purchased by the wife of the petitioner, another petitioner here, it is seized. Now, Milord, so far section 457 is concerned, Milord. Now I pray to withdraw this CRLMC with liberty to file 457 petition before the trial court.
457 for release of what?
Release of the documents and also the deposits.
You are the wife of the principal.
I am the petitioner and also the wife. Both are the petitioner here.
Then counsel for the petitioner seeks to withdraw the present petition to avail remedy under section 457 CRPC for release of the original document pertaining to immovable property. With the aforementioned liberty, the petition is disposed. 20.
May it please your lordship, I am on BC Milord. I am on BC Milords. Milords, the present case is a offense under section 138 of NI Act, Milords. The complaint petition was filed on 12/11/2020-21.
Who are you?
I am the complainant, Milord.
You are the complainant?
Yes, Milords.
Yes.
On 17/8/2022, evidence affidavit was filed by me and chief examination was concluded. Thereafter, on 10/11/2024, I filed a petition under section 311 CRPC for recalling the witness in order to examine one vital document, that is the bank passbook, which will reveal that an amount of 40 lakhs has been transferred from the account of the complainant to the account of the accused.
Yes.
And the same has been rejected by the Honorable Court on 12/1/2024. Challenging the same, I am before your lordships with a prayer to allow me to exhibit the document through the PW1, who has not been at any point of time cross-examined by the accused till date.
You have not cross-examined PW1.
No, the accused person, the conducting counsel for the accused person has till date has not started his cross-examination for the complainant. At that relevant point of time, prior to his cross-examination, I have filed the petition. That check amount involved here
What
is
was the
Milord's.
necessity to, if he was not cross-examined at all, you would have otherwise also you got the opportunity. Why have you moved another application for that?
Sir, I have concluded that PW1, the complainant was examined in the year 2022. On perusal of the record, the brief was transferred to me. I perused the record and found that the vital document, that is the bank passbook, has not been exhibited.
That means PW1 was cross-examined already.
No. Only his examination of chief was concluded.
Where have you said that?
Sir, in my entire averments, Milords.
So tell me, where have you said that?
Yes, Milords.
Cross-examination of PW1 was never taken place.
Para number 4. Para number 4, Milords.
Okay. Right on. The petitioner is the complainant in ICC case number 5163 of 2021 under section 138 NI. Right. He submits that PW1, who is the accused,
Yes, Milords. PW1 is the complainant.
You are the accused.
I am the complainant, Milords.
Okay, PW1. Then you are the PW1. You are the complainant.
Yes, Milords. Yes, Milords.
I don't. CW1, in fact, complainant 1. Why are you
okay,
CW? Right down. PW1. He submits that although the examination chief, although his examination chief was conducted on of 17/8/2022, but he was never subjected to cross-examine, isn't it?
Yes, Milords. Yes, Milords.
Being PW1, being the PW1. Therefore, he moved an application under section 311 CRPC on
10/11/24.
11/2023. The learned court below, by order dated 12/1/2024, has rejected the application.
Milords.
1 minute. Some relevant document was rejected the application. Yes.
That is inadvertently in the petition I have mentioned as 10/11/24. I have filed the petition on 10/11/23, Milords. 2023.
2023.
Yes, Milords.
Yes. And what was the ground of rejection for the referred to the decision of the justice? Passbook could not be linked due to the oversight and even some material facts were left unless limited such as outside the cost is the one includes to light production. Hey, the trial court doesn't say that you were never cross-examined.
My lord, that is what I'm saying. The learned court has not perused the record. That is why I have.
Anyway, then this is a controverted fact. I will issue notice.
My lord, I have attached the evidence copy also.
Anyway, order dated 12/1/2024 rejected the application. The petitioner seeks indulgence of this court. Issue notice to the opposite party number. Opposite party, returnable within 1 week. Release the matter. I am issuing notice.
Highly obliged. Highly obliged, my lords.
At 12 minute that I passed over my senior matter and another Mr. Sahu is also similar matter appearing in the VC matter. I might not pray for my lord and take out 1 day after my lord because my lord is scan copy not my lord that is the door code scan.
Day
after tomorrow.
Day after tomorrow.
Day after tomorrow.
Day after. Okay.
Along with that case, Mr. Sahu, my lord.
Mr. Sahu's matter also listed.
Same matter.
Day after tomorrow. Okay. Yes,
21.
May I please, your lords? I'm on VC, my lords. I'm on VC, my lord. My lord, this petitioner approaches Hon'Ble Court for quashment on the ground of amicable settlement among the parties.
Yes.
Earlier, this petitioner has approached with other 7 accused persons. In CRLMC number
21, my matter perhaps.
You are. This is Shobhagya Mahapatra.
Yes, my matter.
Sorry, I am 22. I'm sorry, my lord. My lord,
Mr. Rice matter. Mr. Rice matter 22. My lord, this is matrimonial discord giving rise to a criminal case. And this is the husband and in-laws, mother-in-law and sister-in-law. And offense alleged, your lordship may kindly see cognizance order is at page 7. Now the matter has been, divorce has been granted by the family court, confirmed in appeal before this court.
On contest.
On contest, and some arrangements have been made for permanent alimony amounting to almost 50 lakhs. And first installment, the husband has already paid and wife has accepted. And this case is apparently false case on the face of.
There is no understanding that it should be.
No, it is a contested decree. I filed a petition.
He is now separated, now contested, lost the case.
Yes.
And took some alimony also.
Alimony 50 lakhs.
Still sees the.
Yes. And nature of allegations, your lordship may kindly see. Her father detected that I am getting married for the second time in 2022.
Forget anyway. She may not proceed with this case.
So
after the
yes.
I will notice and
yes.
This the petitioner has challenged the order dated 23/8/2023, whereby cognizance of offence under section whatever
294
under section
294, 323, 354, 494, 506, 34 IPC.
IPC was taken against the petitioner. The dispute is arising out of a matrimonial dispute. Then matrimonial discourse. Where is the, have you filed the divorce and or nothing?
No, my lord, I have stated and I have got
Mr.
a,
Mishra, Mr. Mishra, learned counsel of the petitioner submits that the parties have the court, the family court. Which family court?
Khorda, my lord.
Family court Khorda has allowed the divorce petition filed by his clients on contest, and permanent alimony has also been paid.
No. Decree ହେଲା ପରେ ସେ ଆସିଲେ appeal ରେ ମୁଁ ବି ଆସିଲି appeal.
अच्छा, कौन है? Family court Khurda. Okay, directing for 50 lakhs permanent alimony.
30 lakhs here.
सेठी करते लगा.
ना सेठी करथिले 15 ना 20 lakhs, एठी 30 lakhs कले.
अच्छा, with direction for paying only alimony. Cross appeals were filed by both the parties, and in the appeal, the decree of divorce was confirmed, and 50 lakhs rupees was directed to be paid as a permanent alimony.
Yes.
Out of which 25 lakhs has already
No,
been paid.
first installment केते देते?
Taken 15 lakhs full amount.
15
And
lakh.
for child granted and
And how much you have paid?
केते?
A part payment has been made, right? And part payment towards the alimony has already been made. Has already been made.
that is 40 lakhs.
And in view of the aforementioned developments, the counsel of the petitioners seeks indulgence of the court for watching up for the present watching up for the FIR.
No, complaint
Complaint case. Complaint case being CC case number so. Being one CC case number, कौन से रहता है?
One CC case number 87/23.
87 of 2020. Issue notice to the opposite party. Written evidence also. Mr. Raghuram appears for the case and waives notice. In the meantime, next paragraph, I लिख दो. In the meantime, further proceeding before SDGM Nagar in ICC case number 87 of 2022 is staged.
State
not party complaint.
Complaint case.
Complaint case. FIR any?
No.
Stay. If she comes,
yes,
she has taken the money, you pay the
yes,
money, it will be settled. I'll just come.
May I please, your lordship?
Yes.
Lord, the petitioner before this 482 application for quashment of the entire criminal proceeding on the ground of compromise, my lord. Earlier, my lord, earlier he has approached this honorable court in CRLMC number 2360 of 23. That is there in the with the your lordship's record, my lord. His petitioner is a juvenile.
Now,
But he was
forget about merit, but they have settled their dispute. What are the offenses?
My lord, offense is 386, 363, 364, those offenses.
What is the terms of settlement?
My lord, they have amicably settled, my lord, because they are belongs to one locality, one street of Parlakamdi, Kasinagar.
They married or what?
No, but one small child was kidnapped, and his father has lost this affair. But when the child was found from his own factory, my lord, the matter was amicably settled because there was a communication gap between the parties for which this affair was lost. And your lordship has scored other 7 accused persons.
Notice. I am issuing notice and bring them first week.
I will call him
first week. Notice. And whatever the connected matter you are talking about.
My lord, 2360,
yes.
My lord.
That is there already there. And
Yes,
both the case both the matters we can dispose of on the same day.
That was disposed of. In that case, my lord has caused the application of this petitioner even. In that case, he is a minor, my lord. It was not brought to my notice, for which I have filed. For which I have filed CRLMC 2360 of 23. In that case, this petitioner is also an petitioner.
Yes.
There are 2 cases.
Yes. Your lordship has quashed
2 cases.
1 case quashes.
No, 2 case, no. Say same case.
Outer kind quash
No, because his case was transferred to PMJJB, my lordship, because he is a juvenile at the time of occurrence.
Okay, that case. Okay. Issue notice. Notice.
OP2.
OP2.
And your lordship may.
Sorry. Unmute. Who is this? He's speaking in between. Yes.
My lord,
yes.
Your lordship may direct. Your lordship may direct to call for IA number 6821 of 24.
What is that?
My lord, because the learned court below is not releasing which the seizure items which were seized during the time of my lord inquiry.
I am not there.
You have moved. In which matter?
Yes, because he is not releasing the articles. I have filed an miscase for.
Miscase where?
Not in the list.
IA is 681 of 24. I have already filed.
It will come next time. Whatever IAs are filed. Yes.
That was filed in 2360.
Okay.
Yes.
23.
Well, here in this case, the learned additional session Bhubaneswar has granted bail in favor of the present petitioner. Have gone to page 13.
1-3.
1-3. My condition is that one of the conditions for which he could not able to release the one of the surety must be a blood relative. Relation having ROR in his name. That's why the petitioner is unable to.
You are which condition is talking about?
My lord, page 13. Considering the above, I am inclined to enter the accused on bail, but with certain state condition. Consequently, the bail petition stands allowed. Let the accused petition be released on bail on furnishing bail bond of 50,000 with two
security each.
One
is blood release.
My lord.
Having ROR.
My lord.
This was allowed on?
Allowed on, my lord, 29/1/2024. And
you are outsider?
My lord, no. I am local man. My lord, I got the ROR.
The petitioner by the order dated 29/1/2024. The ad hoc additional sessions judge, Bhubaneswar, enlarge the petitioner on regular bail, with the condition that he should furnish a bond of a bail bond of rupees 50,000 with two solvent sureties each for a like amount, out of whom one of them must be a blood relation having ROR in his oblique her favor. The petitioner submits that there is no one in his blood relation who has immovable property worth 50,000. But that is the reason, despite the bail order, he could not be released. He seeks alteration of that condition. Instead of so then you give any other. Therefore, the bail condition imposed by the court below while granting bail is modified to the extent that the petitioner shall be released on bail by furnishing two bail bond of furnishing bail bond of rupees 50,000 with two solvent surety of like amount.
10,000 cash security deposit करिया कहिछि मालड deposit करि परले मालड 5,000 करले मालड I will obliged.
And he also seeks waiver of the cash security of 10,000 rupees, and the same will be waived. Condition see bail 10,000 he is not capable of paying. Why unnecessary? Cash security. Otherwise also
Cash Supreme Court says no.
Unless that is the reason, what generally is done is put in their own mouth and get right down what to do. Okay. 24.
May I please, let's see. Offenses under 341, 323, 506, 34 IPC,
Yes.
husband and wife, my lord.
Yes.
And FR and counter FR, my lord. The Shishu Bhavana, the child was admission and the husband was come and I have two injection and some meals was threatening me. I have FR lost to Lalbagh PS case number 31 and he was counter FR, my lord, 332.
What do you want?
Madam, the challenge.
FIR, counter FIR is all right.
My lord.
What do you want?
I'm challenging the FR, my lord. False and fabricated FR, my lord.
So,
Working-
investigation is still on.
My lord, recent case, 2024 case, my lord.
So how would I know that it false or correct?
I'm
Police
lost.
has to correct. Police has to see it, not I.
My lord. FR, I'm first FR lost 31.
Whatever,
My
police
lord.
have to see this thing, whether false or right or wrong. Investigation is still going on. Why have you come at this stage?
No, only for no course action, my lord. My child
Yes,
is.
why
My
don't you tell that?
lord.
You have attempted for bail, you did not get, therefore you are coming in.
My lord.
You tell that.
My lord. That's no
Tell.
course action.
But what can I do? If why have you gone to that court? Otherwise, if there would not have been any order rejecting your bail application, I could have done it. Now I can't do anything because I can't alter the order of the coordinator.
No file, my lord.
You have not filed.
No file, my lord.
Go and file. I am giving you liberty. I'll
Only for-
record everything. I'll record everything and give you liberty so that you can go and get the order.
Where file
I'll record them. Whatever you are saying, I will record it so that it will be easier for you to get the anticipator. And offenses are not serious. You will get it. What
Only 506.
506, why are you?
Well, have you
will get it.
ସେ ଛୁଆ ଆଜ୍ଞା ମୋର ଆଡମିସନ ହେଇଥିଲା ମୋ ହଜବେଣ୍ଡ କୁ ଆଜ୍ଞା ଆସିଲି ମୁଁ କହିଲି ଖାଦ୍ୟ ଆଣିବାକୁ ସେ ମତେ ଆସିକି ବାଡାବାଡି କଲେ ଛୋଟ ଛୁଆ ଆଜ୍ଞା ଆଡମିସନ ହେଇଥିଲା ମୁଁ ଆଜ୍ଞା ଛୋଟ ଛୁଆକୁ ଧରିକି ସାଲାଇନ ଆଜ୍ଞା ଶିଶୁ ଭବନରେ ଆଡମିସନ ହେଇଛି ସେ ଆଜ୍ଞା ହଜବେଣ୍ଡ ବି ଦେଇନାହାନ୍ତି ସେ ଆଜ୍ଞା
What he saying is something.
ମାନେ ଦିଅର ଆଜ୍ଞା ଦେଇଛନ୍ତି
41 ରେ ଛାଡିଦେବେ ଆପଣ କାହିଁକି?
କିନ୍ତୁ ମିଛ ଏଫଆଇଆର ଆଜ୍ଞା ଦେଲେ ମୁଁ ଆଗ ଦେଲି ତାପରେ ଆଜ୍ଞା ମତେ ବାଡାବାଡି କଲେ ମୁଁ ଯାଇକି ଥାନାରେ 31 ଦେଲି ସେ ଆଜ୍ଞା 32 ଆଜ୍ଞା ମୋ ନାଁରେ ଆଜ୍ଞା ଦେଇଦେଲେ କହିଲେ ମୋ ସ୍ତ୍ରୀ ମତେ ବାଡାବାଡି କଲା ହସ୍ପିଟାଲ ଭିତରେ
Shall I write? The 41 notice will be issued and he will appear. Shall I write? At least unnecessary. The petitioner.
Quarrel between husband and wife, two families.
ମୋ ଛୁଆ ଆଜ୍ଞା ଆଡମିସନ ହେଇଛି ସିଏ ମତେ ମୁଁ କହିଲି ଆଜ୍ଞା ଖାଦ୍ୟଟା ଟିକେ ନେଇ ଆସନ୍ତୁ
Better than anticipated bail. Wait.
ପ୍ରୋଟେକ୍ସନ
Write
ମାଇନର
down.
ଖାଲି ଦିଆଯିବ My lord.
Write down. The petitioner is seeking indulgence of this court by filing the 482 petition and seeking quashing of FIR number so and so, so and so, so and so. Full stop. Let the counsel for the petitioner submits that it is a cross case and it is a dispute between in the family itself. In the family itself, between wife and husband.
My lord.
Between wife and husband. Between wife and husband.
And their relations also.
And their relations. Relations. Mr. Ragada IPS for the state submits that the both the cases investigation is still going on. This being a dispute in the family and offenses are not serious in nature. In all likelihood, notice under section 41 C would be issued to them, and the petitioners should cooperate with the investigation. I am not inclined to interfere in this matter. It is the field of investigation. The petition is disposed of to their observation. 41 notice.
41A.
41A. 41.
Deep level.
25.
Now, the petitioner prayed for quashing of the one case number 2 of 2005, my lord.
To what, which item?
25, my lord.
25, okay. Yes.
On the ground that matter has amicably settled, my lord. Initially, the complainant was the
Bring them. With
my lord. Well, kindly fix the date, my lord.
First week. 8. Bring them.
5th, my lord.
Fully. Ajani or dinner one.
Kondhamal Rasi.
Online appeal kora.
Hey, 8 तारीख आसो.
Kali.
हाँ, वो नहीं हुई करो हवन.
Kali for dinner.
हाँ जो.
नहीं.
2 तारीख में लास्ट. 2-3 हुई.
नहीं पेरो बहुत सारे बहुत
8 क्लास.
26. Yes.
May I please, Your Lordship?
Yes.
Here, the order under Annexure 1 series is challenged before Lordship. Before going to that, I am giving the background of the case, my lord. Annexure 1 was passed. Earlier, one order in execution proceeding.
Who are you? You are the wife.
No, I am the husband.
You are Srikanth's house.
Yes.
Babita's house.
Yes.
I'll issue notice. Later come, we will see, find out.
No, the problem is now I am in custody. I am in custody. Imprisonment order for 1 month was passed. That 1 month was completed. Expiry of 1 month, I was not been released on the ground that in 4 execution cases, I was arising out of the one original proceeding. 4 execution cases, 4 orders were passed. There was no such indication that the sentences will run one after another. So after 1 month is over, I filed a petition for my
What was the amount awarded?
amount. There are different amounts. Some 1 lakh for 8,000 because it arises after the expiry order.
You have you challenged that expiry order?
Yes, I have challenged that Annexure 4 is appeal is pending before the Lord and
You have not got stay.
I have not got stay.
What is the amount monthly maintenance?
Monthly maintenance different amounts. One is 1 lakh 8,000.
What is the highest amount in which proceeding? DB. Yes,
DB proceeding.
DB 125 everything.
No, what DB, my lord.
DB. What
The
is the
total amount was the
I'm not talking about aerial. I'm talking about the monthly.
monthly is 5,000 per month, 2,000 per month to the petition number 2, 5 to 7,000.
How much will you deposit here? You tell me. I'll pay.
On 6th, I have already deposited 1 lakh 4,000. Still then I have not been released because of there are areas of in respect of 4 execution cases.
Keep on paying. Keeping him inside will not solve any problem. He has to pay the maintenance to the children. It's not a criminal case. How much you will pay? 50,000 rupees. And will continue paying the regularly the maintenance.
Yes, I will continue to pay regular. One thing, 6 तारीख ଲକ୍ଷେ ଟଙ୍କା ଦେଇଛି ଯାହା ଆପଣ ଫିକ୍ସ କରିବେ
Within 15 days, you pay 50,000 rupees and keep paying continuously the maintenance as awarded till the appeal is decided, obviously. And this I'll say the proceeding. At least they should get something. Okay. That is the better. Mr. Mahapatra, Land Counsel for the petitioner, submits that despite the fact that on 6th of March, he has made good a payment of rupees
1,04,000.
1,04,000 rupees. The execution proceeding is still on and he is in custody for non-compliance of the same. On instruction, he undertakes to deposit further amount of 50,000 rupees within 15 days hence. 20 days. Give after all, you are giving it to your wife and
No, that is also disputed question. I can
Anyway,
establish there
20
because I
days.
cannot.
Within 20 days, he'll pay 50,000.
See, I would say bahala pore
And
mona
subject-
DB case file goes.
And subject to the petitioner continuing paying the regular maintenance to the
Opposite party 1, 2.
opposite parties, the execution proceeding. Where is that execution proceeding now?
There are 4 proceedings.
Execution.
Your lordship may say that operation of that order be stay.
Which one? Operation of the order dated. Which one?
Order dated, my lord, that is
First series.
2/4/2019.
Operation of order dated 2/4/2019 is stayed.
Against that, they prefer appeal before the appeal court.
No, the main order I can't say.
So then
The appeal. Only
4
execution I can say. Execution proceeding I can say.
execution proceeding, my lord. The 4 execution
May not be
proceedings.
filed the appeal. Appellate court will see. How can I exercise that?
Execution proceeding 64 of 2019.
Execution proceedings.
Arising out of that.
Arising out of the maintenance order are stayed.
Arising out of DB Mess case 391 of 2017.
Execution proceeding.
Execution.
Okay.
I mean-
Appeal you get it.
Yes.
Okay. Yes.
27.
On deposit, your lordship may say that petition be released for 2 weeks because already he is in custody more than 1.5 months. He is inside custody.
You will be released, but
Your lordship, direct. In view of disposal, your lordship may say that
on the on petitioner furnishing an undertaking before the execution court, he shall be released on bail forthwith. Undertaking in the aforementioned terms,
Well.
He shall be released forthwith.
grateful lords.
Yes.
27.
My lord, petitioner is the informant and a
Notice be issue kar do. Issue notice. Yes.
petitioner is the informant, my lord, is senior citizen of 70 years and suffering from various ailments, my lord. My lord, make deposition by the annexure 3 page 16 on where he stated he at present I do not want to proceed further in this case. Para 3, my lord. Page
Where
16.
are you reading?
My lord.
Where are you reading?
My lord, that is page 16, annexure 3.
1/6.
Para 3. At present, I do not want to proceed further in this case. The second para lekha hai, the matter has already been settled amongst them.
Bring here.
Yes, sir.
No, my lord, one of the thereafter, one of the coagut out of 4 coagut out of 1 has filed a petition under section 311 of CRPC to recall of the witness. On the petition of the one of the coagut, that is annexure 4, the law court below has issued notice to the present informant, my lord, for cross-examination. Therefore, the petitioner challenged the same, and I do not want to proceed the case further, my lord.
You are the informant.
I am the informant.
One of the co-accused
accused want that you should come and depose against him. And informant you have already deposed. You said that I don't want to continue.
My lord.
Still the accused want that you come and depose against.
Another accused.
311 application. And the petitioner is the informant in FIR number PS Balyanta PS case number How much you have taken the money from the two accused? You might have taken the money, therefore you have made that.
ନା ନାଇଁ ଆଜ୍ଞା
The other accused might not have paid you.
70 ବର୍ଷ ହେଲାଣି ବୟସ ଆଉ ଚାହୁଁନି ମୁଁ ଆଉ।
Anyway, informant in so and so. When during trial, he has already deposed that he is not interested to proceed against the accused person. The accused person. He has filed the deposition as deposition at annexure 3. Annexure 3. Annexure 3. One of the co-accused, one of the accused,
ମାଇଲ
all the accused are parties.
ସେମାନଙ୍କର କିଛି ନାହିଁ।
One of the accused, no, one of the co-accused with the opposite party number 2. One of the co-accused with the opposite party number 2, isn't it?
ମାଇଲ
Opposite party number 2 is an accused.
ମାଇଲ
One of the co-accused with the opposite party number 2 has moved an application under 311 CRPC seeking recall of the present petitioner. Present petitioner on the ground that he has not crossed it. The petitioner is agreed by the said order. Agreed by the said order. Issue notice to opposite party, and the accused who has moved the application under 311, you have to make him a party.
ପାର୍ଟି କରିଛି ଆଜ୍ଞା
Who is?
ଅପୋଜିଟ୍ ପାର୍ଟି ନମ୍ବର 2
ସେଇଟା ତ ମୁଁ ପଚାରୁଛି।
ଆଜ୍ଞା
you are not clear about anything. That's the problem. How
my-
many accused are there?
3 accused men
Why have you made one accused? Other 2 accused also you should have made the party.
ସେମାନଙ୍କର କିଛି ନାହିଁ।
Now how you are telling, na? They will come and tell something else. You will not decide whether they have to say anything or not. Make other accused their party. Person. The opposite party number 2. Opposite party number 2 being an accused in the case, move the application of the phone. Okay. There are 3 accused in the present case. The other 2 accused have not been implemented, and the counsel for the petitioner seeks leave of this court to implement them as the opposite party during the course of the hearing, and he will do it during the course of court. Issue notice to the opposite party, Mr. Zagada accept notice, and further proceeding in share so and so is taken. Is not there. Yes. Password.
Item
Is
4.
there. 4, huh? Yes. We are going slow today. Yes.
May please your words.
Yes.
But I have an application before this honorable court challenging the quashing of the FIR charge sheet and the order of cognizance. And at the ground, your lordship is that this is one of the 7 of the PC Act, your lordship. 7 of the Prevention of Corruption Act.
Yes.
But it is alleged that I have demanded a sum of rupees 12,000 for the purpose of giving the matriculation certificate of the informant who has lost the FIR. This is what sort of some allegations. Then
You asked for 12,000 rupees
for
to
the purpose of providing the SLC, full living certificate of his daughter,
okay.
for the purpose of taking admission in some other colleges after he has been passed out from that school. So a preparation report was made, and when a trap was laid, thereafter, your lordship, just have a glance. My wholesome allegation is that this nothing was seized from my possession, as is reflected from the seizure list, your lordship. First, second, your lordship,
It is not a gratification. This 12,000 rupees, it was a due which was against the daughter of the complainant, which was maintained in the school register, the 12,000 rupees. All it, I have filed all these
Which
documents.
class you are studying?
12 pass out students.
12 pass out and 12,000 due. What kind of
My lord, I'm just,
government school 12,000?
well, I'm just saying, your lordship, just have a glance. But first, your lordship, it was not a gratification towards of any work to be done. It was not. It is the dues which was pending against it. First, secondly, also nothing was seized. That 12,000 rupees, which was planted, it was not seized from my possession, which is
Where from it was seized?
my lord. Just have a glance.
You tell me the facts. You tell me.
It was seized from one Sheikh Firoz and
And he was peon.
he was a mechanic of that school, pipe
On
mechanic.
your instruction, it
Pipe mechanic. It was not seized from me. And your lordship, your lordship, just have a glance over these documents. The documents, your
What is the
lordship.
case now? What is the says? It is cognizance says.
And in spite of this, cognizance has been taken. In spite of this, your lordship,
All these things has to be verified. The fact, whatever you are saying, has to need to be tested in the trial.
it is palpably clear from all these reports which has been submitted on section 173 CRPC that even if it will go to the trial, your lordship, it will be an abuse of process of court. Your lordship, ultimately what the court will hold, your lordship.
How do you say that?
My lord, I'm just saying. Your lordship, just have a glance at page 24, your lordship, just have a glance.
24.
Page 24.
Yes.
This is what the detection report is. This is Annexure 3. Detection report, your lordship, first column, your date, time, 26/8/2022 from 11:45 onwards, your lordship.
Right.
Well, next page to 33, your lordship, just have a glance.
Page
33.
33.
My lord.
Yes.
33 is the seizure list.
Yes.
Well, one thing you will have learned from who place of seizure. Date and 26/8, second column, place of seizure. In the office chamber of Sri Sanjay Kumar Samal, myself. From whom seized? Next bar, next three. From the possession of Sheikh Firoz, son of so and so, and the denomination, your lordship, is serial number 5 description article seized. So it was not seized from me, your lordship, and it is not the case of the prosecution.
The prosecution has to prove how the Firoz is related. Firoz is also an accused.
He has not been arrested by accused person.
He may be a witness.
He has not been. Second, your lordship. Second, your lordship.
These are the documents. How can I see the veracity? They have to substantiate it. These are the prima facie case. There is a demand, there is an acceptance. Acceptance is through XYZ. They have to establish the link in the trial. Whether the XYZ is related to you, on your command he has received it or not. Those are the things.
No, it is not the case of the prosecution at all in the entire investigation, your lordship. It is not the prosecution that this amount which has been seized from the possession of the Sheikh Firoz has been given to me.
How do you relate Firoz with
or your lordship?
If that link goes, everything goes.
Your lordship, kindly see the detection report. What has happened in this case? Page 24. 26.
Okay, 26.
27, your lordship, relevant portion, your lordship, kindly see. He, on the date of trap, he entered into the chamber.
26, 1 minute.
27.
Yes, you tell me.
Bought out the tender, then accept the demand part, your lordship, kindly see.
Where are you reading?
25, your lordship, kindly see. Last part.
25. Okay. Here.
Being asked the company witness so and so, and that
today on Sunday,
so and so went inside the school compound, proceeded to the office chamber of headmaster of the school, and he followed the complainant. Before entering into the headmaster of the chamber, the complainant identified him, the accused headmaster, who was sitting in his office chamber. As per instruction, he was present near the open door of the said office room at an audible and visible distance. After identifying the accused to him, the complainant went inside the office chamber room of the accused headmaster and asked him regarding the issue of matriculation certificate of his two daughters. On this, the accused Samal headmaster asked the complainant whether he has brought the demanded bribe money of rupees 12,000. Here the demand.
Yes.
When the complainant Sri Lakra replied in affirmative, the accused Samal headmaster directed the complainant to hand over the same to him. Accordingly, the complainant brought out the total tendered bribe money from his left side pocket and handed over the same to Samal, headmaster.
How it has been seized from
Let
Firoz?
me complete. Let me complete. Headmaster, who received the same by his right hand and counted it using both hands and kept it in his right hand side pocket of his wearing full pant. He was also close proximity. That is the statement that the overhearing.
Yes.
Heard and conversation between the complainant, accused had and seen the transaction of bribe money between the complainant and the accused. By that time, full stop. By that time, one person entered inside the office chamber of the headmaster. Seeing the transaction of the one person entered. That person is the electrician to whom he has given the money. Next page, your lordship.
Where you have stated?
Next page, your lordship, can you see? Next page, 27. The second line. The accused Samal admitted that
And
he has.
have you conducted phenolphthalein test?
Yes, his hand wash was positive, pocket wash was positive. Then your lordship, that is the detection report itself says.
Phenolphthalein test.
My lord.
Confirm that you hold the currency. You hold the currency,
even if that-
given it to the electrician, it is recorded from the electrician.
And he has stated, he has stated that I have.
Submit your lordship. Why your lordship? This 12,000, if it is philanthropy test is not the also sole criteria to base with the conviction. Prima facie, your lordship.
Cognizance order you are challenging.
And the FIR initiation proceeding, cognizance order, your lordship. Thereafter, well, this is one point, your lordship, and the tendered money have not been seized. Your lordship, they are well within the office, within my office. If it has been recovered from my pocket, why it has not been seized at that time? Because all the persons are there in the room.
No, what?
Why they have waited? Why they have waited
You
till
must be
the
holding it.
till the
You might have, by the time interaction is taking place, you might have taken it and given to the
well,
electrician.
in presence
You
of
are smart enough. You
my
know
lord,
that it will not be recovered from
in,
me.
in, in presence of three persons, three vigilance people, so I have handed over the money to a third party in my chamber,
Why all these
and in
things?
presence of this person.
These are matter of inquiry and trial. I can't.
My lord,
I can't presume something.
because then, my lord, that 12,000, dear lord, we just have to keep on how this headmaster has been came the prosecution. 12,000 rupees your school register is maintained. Your lordship page 170.
Sir, all these things are matter of trial.
Page 170. Just on a page 170. Just on a glance over your lordship.
Conduct a trial in this.
Well, I am not in the trial, your lordship. I am your lordship submitting the abuse of the process before the trial court, your lordship.
You have to go.
It will be abuse of the process, your lordship. Ultimately, what your lordship? That's why, your lordship, I am pressing hard before your lordship to satisfy.
You are doing your
satisfy.
job. There is no doubt about it. But how to come to your rescue?
Well,
These are the materials.
Just page 172, your lordship, just a glance.
172.
172 of the CRLMC application.
172. Okay.
Annex of 13. This is.
Yes.
This is what the HSC class 10 result sheet. Well, first column, you'll have the students list. Last column, you'll have the remark column. What are the dues pending against them? You'll have these are the dues.
What is the
noted.
name of name?
My lord, just have a glance over page 174. 174. At serial number 78, your lords.
12,000.
Priya Lakra. This is what, and the amount due was rupees 12,000. This is what the amount due, and as for the my lord, question was put to me how in a government college this amount was collected. By your lordship, put a question, your lordship. Well, that notification also I have annexed, your lordship.
This is due to towards what?
These are the dues pending against these persons, because that is the notification. Why we have. He is not the only student, your lordship. He is not the only student. The entire student. My lord, just have a glance over that notification of this government, state government. Page 177. Because, your lordship, for the purpose of development of the students in the government school, in absence of some teachers, we are procuring some private teachers from other institutions. So as to upgrade the
177, where does
for which
you will burden it to the children?
My lord, page 177, annex 14, your lordship, just have a glance.
Yes, I am there.
My lord.
I am there.
Page 178.
178, yes.
My lord. serial number, clause number 12. This is where the office of the BO office, Sanjay Samal, in charge headmaster, had engaged teachers and other staff on the decision of the SNC PTA at Kumujharia UGHS for the interest of the students, but he has not taken any permission from the competent authority. This is what the he has not taken any permission from the competent authority. My lord, for what I have collected, it is not my own decision.
Where does it say that you can collect money from the student?
My lord, this is all.
You have engaged, it's all engaged, no problem.
My lord, I
Can
have,
you burden it to the
my
student?
lord, if I have not taken permission of this from the student, from the government, and the amount has been collected and has been disbursed, can it be attracted to 7 PCA university? I will file face the charge of trap kare दी कि मतलब धरिक मेरे enter character नष्ट करूँगी. Disciplinary proceeding can initiate कॉल नहीं mobile. It is
para 14
why disciplinary proceeding has not been initiated.
সেই পেজ 14 নম্বর ক্লজটা 14 নম্বর ক্লজটা দেখুন
वो সেটা পড়ুছি.
There is no fee, fine,
Fine
thereafter
for the students of the government case and so on.
then
My lord, that is,
for SLC
There is,
my lord,
there is a rider.
I do admit that there is no fees under the government, but your lordship, for the purpose of development of the students, your lordship, parent teachers meeting was held.
If
And
that is the case, 72 you have shown, why few students are left and why few students are charged, you tell me? Why have you selectively
No.
charging?
No, my lord, all the students have, my lord,
Just
12,000.
see the list. No due, no due, no due, and few people are charging.
My lord, no due means,
Few
my lord,
people are you are asking 600, few people.
my lord,
12,000.
my lord, I am explaining. No dues means they have paid, and against these students,
No,
it was not dues.
Why the figures are different?
Figure is different because suppose out of 12,000 rupees, my lord, out of
Somebody you are
12,000,
asking 19,000, somebody 22,000,
my lord,
somebody 20,000.
I am explaining.
You are extra 300,
My lord,
3,000.
my lord, I am explaining. I am
You are a
explaining.
teacher,
My lord,
in a school, government school, you are extracting money from this.
no, man. I am explaining. I am explaining why. My lord, the dues was 12,000. Somebody has paid 10,000 rupees. Then the remaining amount 2,000, it was just written in that.
Then
it was there.
it is again a scandal, you know.
It is one because your lordship, my lord, this person was selected for the award, your lordship, by the government.
What is the basis of this? How have you arrived at 12,000? You show me.
That I will show your lordship.
This is the matter of trial. Okay. This is what is the matter of trial.
Well, 7
Trial is
PCI,
nothing else.
can it be
In a
treated as a
cognizant
gratuity?
stage, I can't see the
My lord,
document sheet.
can it be?
Why have you charged 3,000 to X student? Why have you charged 12,000 to Y student?
My lord, my lord,
This is the matter of
my lord can also scrutinize the document as per the DN party's case, your lordship. My lord knows that. My lord, my lord, there is actually, in fact, no fees is to be collected. But when a fees has been fixed after the meeting of the PTA association, your lordship, and I am citing certain judgments.
You give the judgment reserve, you give it, I'll pass it.
But 7 PCI is not made out, your lordship, and there is not a gratification for any review.
I will pass an order. Just see, it is a cognizant stage. If I pass an order, I have to observe everything. Then you may be prejudiced. So it's better that you should better try at the appropriate stage. See, I have to see whether prima facie case is made out.
That
This is prima facie case made out according to me, and you know that. Even you also will agree with that. So therefore, in a cognizant stage, 482 is not the remedy. If you want, I will reserve the judgment, pass the judgment. As you.
Well, sorry, my lord, I want the judgment. Judgment.
You give the judgment.
The right.
Give.
Right.
Judgment reserve.
And another aspect I want to bring your lordship's kind notice, the period in respect of which they are saying that we are rendering teaching by engaging other staffs. That period that was closed due to COVID-19. That was the record, their own record says.
Which one?
Your page 180, your lordship.
Why have we not initiated disciplinary proceeding?
Why should we initiate disciplinary proceeding?
What is the
You give a 1-page note.
Well,
You give one.
One judgment, Supreme Court judgment, and coordinate judgment that the justice
Give the, write down the paragraph and give.
My lord.
not a reference to the
My lord, give.
Yes, next.
lordship direct him to sir, a copy of that.
Sir, give a copy and
So that I
if you
can.
want to give a short printed note also, you can give, no problem.
My lord, some 2 pages note.
2 pages. Don't give more.
My lord, 1 day time may be given.
Ah,
Right.
no problem.
By next week.
You give at
Right.
least 1, 2 page, whatever pages you want.
My lord, by oh bless.
Copy
Yes.
the
28. Judgment is.
May I please? An application for quashing NBW dated 14/11/2023 in connection with ST case number.
NBW, you are on bail.
My lord. Yes, my lord.
Tell me the date.
Coordinator का लाची.
Eh?
Coordinator bail जाएगी.
Date.
आज ही 25 अप्रैल कर दो, 25 अप्रैल कर दो.
बहुत आगे.
Bail, NBW issued on 14/11/23, 500.
Oblast.
29.
My lord, NBW issued against the present petitioner on
Bail, you tell me when you got.
bail on 2/5/2016.
2/5/2016.
Yes, ma'am.
16. Sini 9/2021. 9/2021. 500.
Oblast.
30.
May I please? Belgium matter, my lord, NBW 22/8/23, my lord.
Bail.
Well, exactly date is.
On bail, 22/8/2023. 500.
Bless.
31. Yes.
Page 27, I will also have a glance. Page 27.
Yes.
The first order is 5/4/2021.
27. Okay.
Yes, page 27.
Yes.
Your lord, benefit under section 41A was granted to the petitioner.
Hmm.
Charge sheet was submitted, summon was issued. We have not received any summon. Straight time magistrate has issued non-bailable warrant, next order.
Okay, I'll see.
My lord, miss.
What's it? How much you will pay?
But about 11, 12, 12, 23, my lord.
41A notice was granted.
Order dated 11, 12, 23. SRs of summons return back after a due service.
Okay, now
against the-
he's going to appear white.
That is my case that we have not received any summon.
41A notice was granted. Subsequently, due to non-appearance, NBW was issued on
11/12/2020.
11/12/23. And what is the how much you will pay? Now you have to pay more because you are coming. Why are you coming? Unnecessary. 4 people.
No.
4 people, I will pay.
It is not a Belgium, that's why I have come.
It
It is not a Belgium.
we consider it to be Belgium. 41A notice was given.
Yes.
Thereafter, you have not issued someone. You have not received someone.
We have not received summon.
Received someone, but they have issued someone. Forget about everything. Now NBW.
NBW.
I am saying the NBW. You appear on or before 25th of April, and seek the remedy. 41 notice was given. You will be granted bail. Pay cost to the bar. As simple as that. Because a senior counsel is appearing, so the cost is more. As simple.
5 associates, madam.
So 1,000 each for 4 people.
One. In the bar association, there is no difficulty.
Bar association only.
Here,
All costs
to bar
for bar-
association, I am making payment. There is absolutely no.
500 each for this. We use arrange 500 each. All welfare fund.
Yes, yes, no problem. Absolutely.
25th April, on or before 25th April, let them appear and seek the remedy.
Bar
You
association
need more
होते
time
हैं।
than I give.
Bar
More
association.
time is not required. Only
Only
difficulty since NBW has been issued, let me not.
No, I have stayed it. Stayed it. Keep it. NBW is kept in events till 30th April. 30th April 2024. Meanwhile, the petitioner will petitioners will appear before the court below and avail remedy under law.
My learned brother has.
That
no-
also I have written that 41A
Ballot
notice.
one indicate.
I written. Petitioners have received, first like the petitioners have received 41A notice. However, after filing of the charge sheet, it is alleged that the summons were issued to them, but the petitioners have never received the summons, leading to issuance of NBW.
My learned brother has no hesitation in giving.
Please. 32.
32, my lord. This is a Belgium matter, my lord.
Order dated 31/7/2023, my lords. Earlier petitioner was on bail, my lords.
Bail when? Do you have the date?
Actual date is not with me, my lords, but
On
petition
bail,
was
on bail, NBW issued on 31/7/23, 500. Okay. 33.
May I please, my lord? NBW against the 17 ki 23, my lord, the present petitioner second time bail jump, my lord. Second time, my lord. Admit.
Don't make it third time, huh?
My
I'm
lord.
passing it. Okay. Oh, bail, when you got the bail?
My lord.
Bail, do you have the date when you got admitted to bail?
NBW dated 17 ki 23.
Here on bail, 17/1/2023. Bail, 500. Okay.
My lord.
Okay.
My lord. Okay.
34.
34, my lord. I may be permitted to place the matter on behalf of Mr. Panigraim.
Yes, yes.
Here the annexure 2 and 3 under.
NBW issued.
Yes, my lord.
When you were on bail on?
No, my lord. It is a private complaint, my lord. Private complaint case. That I was appeared and took time. Thereafter, I lost the track over the matter. Therefore, the NBW has been issued. Thereafter,
Okay, now you are accused.
Yes, my lord. I am the accused.
In 138 case, huh?
No, my lord. One CC case.
One CC case. Okay. Lego, the petitioner is accused in one CC case number 31 of 2001. Due to his default in appearance in the court, NBW was issued on
NBW issued on
2/9/2002.
2002.
And
subsequent to that,
the same was not executed. Therefore, a fresh NBW was issued on 12/8/2021. He seeks quashing of those orders. He undertakes to appear before the court on or before 25th of April, and seek remedy under law, subject to the petitioner appearing on or before 25th April 2024 and paying a cost of ₹1,000. The NBW issued against the execution of NBW issued against the petitioner shall remain in, okay, it shall be kept in abeyance till that day. Okay. 35.
may I please? Bail, my lord, 8/9/22.
8/9/22.
22.
8/9/22 bail.
NBW
4/1/23 NBW 500.
Obliged.
Yes. 36.
May I please, my lord? My lord, here the petitioner is deceased father, my lord, and the accused is the DSP of police in Odisha Police.
What is this case?
Yes, this is content, my lord. My lord, the judgment starts from page 9, annexure 1, my lord. The operative portion of the order starts from running page 32, my lord. Here, re-investigation was directed to the crime branch.
32, huh?
Yes, my lord. Operative portion of the order. May I read, my lord?
Okay.
For the foregoing reasons, therefore, the CRLMC is allowed. The court directs that
1 minute, sir. 1 minute, sir.
Sorry.
Yes, 32. Okay.
Yes.
For
Running
foregoing
paragraph 15, my lord. For the foregoing reasons, therefore, the CRLMC is allowed. The court directs that the case shall be re-investigated by the CID crime branch, having regard to the fact that one of the accused person is himself a senior police officer in the rank of Deputy Superintendent of Police. It would be proper if the investigation is conducted by an officer of the rank higher grade. The court therefore directs the Additional Director General Crime Branch, the present contemner, to entrust the investigation to a senior officer not below the rank of the Deputy Inspector General
What
of Police.
happened now?
They have not yet started the investigation, my lord. In the meantime, 8 months has been passed.
My lord, on 13/3/2024, my lord, my instruction call for my lord. And take no short answer. I will obtain the same, my lord.
No notice was issued.
Yes, ma'am. No notices, my lord. Just record, my lord.
As because I
302 offense is there. They are sitting of the matter. Re-investigation directed.
Short for my lord, the instruction on 13/3/2024, my lord. Short date, my lord, I will obtain the instruction. This further.
Day after tomorrow.
Obliged, my lord.
It's the contempt.
Yes.
We tend to be
Day after.
Deeply obliged, my lord.
day after tomorrow. Huh? Keep it day after. You seek instruction whether they have initiated or not. If they haven't done, then I'll issue. I'll frame the contempt notice and issue.
37.
Don't ask for time,
No, my lord.
because time bound, the order was time bound.
My lord.
Yes, my lord. It was also
Just
as immediately as early as possible, my
there is
lord.
no time bound.
No.
Then they can seek time also.
Yes, my lord. One humble submission that I wanted to clarify. So your lordships.
If there is a time bound thing, if they have not done, then I will frame the notice. If there is no time granted to them to do this, then they can seek time.
My lord.
And I'll
That's
what is
why, if my
undertaken
lord
to-
permit now, I want to take your lordships to page 33, my lord. The previous I is directed to transmit the entire case diary and all other records, documents collected during investigation to the CID crime branch forthwith. Forthwith has been in several judgments. Honorable High Court, Honorable Supreme Court had directed,
That might
define the
have been-
forthwith.
That might have been done. I don't
My lord,
know.
8 months, my lord, in 3-0 case, where is the accused is a deputy superintendent of police, my lord.
All angles.
And my lord, what?
Sometime if the police does the work little early,
But that's
the people make an allegation that what was the urgency? Why have you done
My lord,
it?
investigate, my lord, here the one humble submission.
Anyway, day after
My
tomorrow.
lord, instruction.
Tomorrow, my lord, tomorrow.
Day after tomorrow.
Day after tomorrow.
He has to.
Oh, my, yes, from Cuttack, my lord. They will take it from Cuttack.
He'll get it.
My lord, day after.
Yes. 37. Pass over.
39.
38.
39.
39, same budget. 39, they have not solved copy.
38 withdrawn. 39.
39, they have not.
39.
39, then. 39.
39.
39. 39 and 40. They have not solved the copy. It's a vigilance matter. They have not solved the copy. But there is the defect is there also. Lots of defects are there.
Right. 39.
May I please, Your Lordship?
The registry has pointed out certain defects in defects which has not been cured, and copy of the petition has also not been supplied to Mr. Manana. Mr. Manana is for the opposite party. Yeah? Let the needful be done and leave the matter. Yes.
41.
What's you praying for next week?
41. Adjourn.
My lord, may I please, Your Lordship? My lord, I'm in virtual mode, please. For this 39 and 40, 4 weeks adjournment may kindly be allowed for removal of defects.
I've adjourned. 13 and 44 is for again. Yes.
42. 42. 43. 44.
It
will reach just now.
Okay.
45.
45, let's see, containment next week, my lord.
46.
Well, I only seeks for 2 months time extension. In fact, I am conducting the argument over there.
Dima service or you?
I just want 2 months time.
In a lighter vein? Dima service or you? Sir, 45 दिन ଦେଇଥିଲେ.
Quite right.
And he is well acquainted with the case.
But he is asking for 2 months.
2 months. That 45 दिन
it is expiring on 22nd, my lord. In fact, they must be Maginothanti. Well, there is a lot of volumes and certain police papers which have been provided to me.
ଗୋଟେ ମାସ ଦିଅ 45 दिन ଦେଇଥିଲା ଆଉ ମାସ ଦିଅ. କାହିଁ ଏତେ ମୋଟା
So within 45 days.
Quite. Our 60 days. In fact, since
60 days. Voluminous. The page.
This is a preemptory order, basically. It says that shall not prolong the application.
Quite. ମୁଁ ନିଜେ ଯାଇକି ଆର୍ଗୁମେଣ୍ଟ କରୁଛି 3 ଥର ଗଲେଣି ଆଉ ଏପଟୁ ଛାଡିକି ସେପଟୁ ଯିବା ପାଇଁ ମୋ ପାଇଁ ହେଇଛି
ସେ voluminous document.
Any objection?
No, voluminous document. Lighter vein. Voluminous in terms of fees.
Right on. By the order.
1 month they did.
By order dated 7/2/2024. The application under 239 CRPC moved by the petitioner was relegated to the court below to decide afresh within 45 days. 45 days with the rider that the petitioner shall not prolong the hearing of application by seeking unnecessary adjournment. Mr. Das appears for the petitioner, states that in the application will be good. States that by the last and final opportunity, 2 months time shall be granted so that we can conclude the argument. In view of the fact that voluminous documents
And hearing is on also, 3 dates have been held.
voluminous documents are there in this case, and 3 hearing has already taken place by now. Mr. Maharana appears for the opposite party and submits that
The objection.
submits that he has a serious objection to this tax.
Oh, he had said faint objection.
Serious objection to the tactics adopted by the petitioner. However, he says that the time granted should be the extension so granted by the court shall be the last opportunity afforded to the petitioner. Accordingly, by way of last and final opportunity, a further period of 45 days.
Sorry, Madam. Sorry.
Further period of 2 months is granted granted to the court below to decide the application under 239 CRPC moved by the
Good. Obliged.
Pura decision.
Item 43, 40, just possible.
No, I would fix up cotton specifically in table.
So that court will control.
In table. That's specific in table.
I don't know how.
No, Aji specific fix list.
Again.
No, I would set and
What do you want then?
So in table, how about
In that case, vigilance is not, presence of vigilance is not required, I think. Though vigilance is a party, vigilance is ED will, pursuant to that vigilance case, ED has taken up the
pension
investigation.
has been attached and the PF, everything has been attached.
So,
Lordship had fixed it up to 3 o'clock. Yes, at 3 o'clock.
Board is adjusted, then I can take.
43, 44 minute parties are
43, 44 years.
the appearing matter.
May I please, your lordship?
What is
43, 44, both are the case and counter case.
Occasion matter both, in fact, the
Complainant and
injured
injured.
person, both the parties not come here matter, for that is not the urgent case matter.
Order
Today they are appearing. First 43 matter.
43.
43.
43,
43 na? First, how the 43 key case is 43 right? Yes. Dangu.
Complaint is a Sudarshan Pradhan.
Who is the Lingaraj Behra?
Complaint is a Lingaraj Behra.
Lingaraj.
And the injured is injured.
Injured or complaint?
Injured.
Injured is a party करना था लेकिन that's be injured.
What are the offenses? Simple.
Simple.
Injury simple. Injury.
But matter they have to produce injury.
I've already filed the injury report.
There is.
Simple injury.
ना लिखने.
Ma'am, what injury report? Injury report. 3471.
Happy.
Simply, to injury simply.
Right now. At the instance of opposite party number 2, who is the author of the FIR?
Lingaraj Behra.
Or the instance of opposite party number 2, the FIR number so was registered against the petition. Injured for
Manager
Happy alias Chandan Maharana alias Happy is the injured in the present case. Under section 2 injured in the present case. Both the informant and injured as well as the accused persons are present in the court. present in the court. That counsel for the petitioner through a memo has placed on record the injury report. Injury report. The perusal of injury report indicates that the injuries are simple in nature. Simple in nature. The parties have settled their dispute and filed an affidavit. Dated 7/8/2023 inter alia, stating that they have settled their disputes on the intervention of the village entry and well-wisher. The opposite party number 2 petitioners, along with the injured, also happy are present in the court. They are being represented by the respective counsel and being identified by them. They filed self-attested copies of their Aadhaar card, which are taken on to establish their identity, which are taken on record. Mr. Arora appears for the state and submits that although the alleged offence is under 307 IPC, but the perusal of the injury report indicates that the injuries are simple in nature
And not any vital part of the body.
and not on the vital part of the body of the vital part of the body of the injured, and the fact that the parties have settled their dispute, there is no legal infirmity in quashing the FIR. Accordingly, the FIR number so reporting what the petitions are passed.
All the petitions.
Everybody has to give 1,000 each. नाम तो के डांगू दिलू गंगू नरना कालिया सेमानकु तमनकु किछि सेमाने किछि कोन देले पैसा देले
पैसा तो तुम देले कि
कोन
नाइ कोनी ना हम भितरे मिला सही छै पैसा
दिनंदी
तुम खंडा करे पैसा मेडिकल ट्रीटमेंट चार्ज के देला अल्प पैसा तुम देइछ
केते पैसा अल्प
केते सा खर्च करछ अल्प पैसा 4000 टका खर्च कर
1,000 all of you five of you pay 1,000 each to the injured.
So another thing is that the case number has been wrongly mentioned in filing register. E-filing register.
During pendency of this CRLMC, now it is changed to sessions court.
Sessions court.
PSC start. My lord, I have given the memo.
I have already given memo.
Memo da diyo memo da sarla 43 sarla
44
subject to petitioners, each petitioner paying 1,000 to the injured. Happy. ठीक है. Next 44. I reckon
there are 2 injured, my lord. And one is Sudarshan Pradhan, my lord. He sustained grievous injury.
Sudarshan Pradhan. How
he sustained grievous injury, my lord.
Grievous injury. How? The cross case.
My lord. Sanatana Pradhan. Cross on the case counter case.
Sanatana Pradhan case.
Sanatana Pradhan. तार हेड अछि तो से कोजी पड़ी गला बेली fell down from the 3-star
Fell down from the stair
height
at home.
The one of the injured and another injured man sustained one injury that is grievous in nature. But since
देखो the CFIR रे करिवा 44 the at the instance of opposite party number 2 FIR number so under section so registered against the petitioner समझला तापर लिखो की फाइल करथिला a cross FIR next one a cross FIR was also filed into the present parties being FIR number 43 FIR number 43 FIR number and on the ground of settlement, the parties had filed CRLMC number 3471 of 2023. While order dated as if also, this court has allowed the press and quashed the state FIR. The present FIR is is a cross FIR, where in this case as well the parties have settled their dispute on the intervention of the village entry and the well wishers. The parties have filed affidavit. You have filed compromise petition. Parties have filed a compromise petition, which is placed on record as Annexure 3. Annexure 3. Annexure 3. There are two injured in the present case. Being two injured in the present case, namely the opposite party number 2 and 1.
And Sudarshan.
Sudarshan to he is, na?
Sadanand. Sanatan.
One Sanatan. One Sanatan Pradhan. Both the injured have received various injuries on their bodies, and one of the injuries is grievous in nature. However, it has come on record that the said injury is caused because he fell from the.
But Sanatan is concerned.
Overall, he fell from the staircase. Fell from the staircase during the couple. Staircase during the couple. Mr. Ragada appears for the both the injured person and the petitioners are present in the court, being represented by their counsel and identified by them. They filed self-attested copies of their Aadhaar card, which are to establish their identity, which are taken on record. Next one. Mr. Ragada appears for the state and submits that since there were two FIR, which are cross cases, and the parties have settled their dispute, and this court has allowed, insofar as the quashing of the other FIR is concerned, there is no legal impediment in giving indulgence to the present petitioner and quash the present FIR as well. Taking into consideration the aforementioned facts and circumstances, the FIR and consequential proceeding for the petitioners are quashed, subject to the petitioners. Subject to the petitioners paying paying 5,000 each to both the victims. Sharing equally amongst themselves. You pay it and the payment.
Since BCI member are member from our state.
You make sure and give a proof.
Okay.
Also, he will give something to
pass resolution against you.
Okay. It will be deposited before the High Court bar.
High Court bar is something.
Make sure that this.
But they will get my lord. They definitely victims will get my lord. But in fact, he has to deposit something.
I have filed. I'll file.
How much you will pay?
10,000 I'll pay.
Both the cases.
And
then to the High Court bar.
I will pay 5,000 to the victim and 5,000 to the bar.
High Court bar
in welfare.
Okay.
You pay that.
Yes, my lord.
Obliged, Lord. Let counsel for the petitioner submit that apart from paying cost to the victim, the parties would also pay 5,000 rupees to the welfare fund of some. Put it in his mouth. Pay it. Question.
Obliged, my lord.
47.
I am in the which matter. Two cases has been registered my lord by the Panjipani by one by the forest department my lord, and another is the police.
Yes.
On the same cause of account in the very date matter. Now my lord, in the forest by lodging a case under 27 of the Forest Act my lord, allegation is that a truck was flying on National Highway 55 loading with candle in my lord. Now my lord, on the detection, the truck was apprehended near Kanjipani Ghati in Kenjor matter. The forester searched the truck and found Kenduli was loaded in the truck. He demanded license authority to the driver. Driver failed away matter. One person was sitting in the truck. He failed to show the necessary document. Thereafter, he was arrested and forwarded in the forest case matter. 27 for attack, read with section 14 of the Kenduli to the JMFC Yonjor matter. And matter, in that case, he is in acquitted matter. Now, matter, on that case, the further
What do you want?
Matter, in this case, I beg to submit you for lordship that once the JMFC holds that this activity is not the owner of the truck matter, in the GR case, he has been implicated for 24 cities. Taking false number plate in the truck and transporting and showing false document for the Kenduli matter. Since I am not the owner of the truck and there is no evidence that I was traveling in the truck, how the police regiment knows? That is my only solution.
What I gather from the record, my lord, there are two cases, my lord. One case, my lord, so far the section 21, my lord, the TT Act, my lord, and another case, my lord, here in the case, my lord, the fake number plate, my lord. For that reason, this case, the present case initiated against the petitioner, my lord. And in fact, my lord, petitioner filed an application that is CRLMC number 2908-2010 that is disposed of 25/6/2019 with liberty to raise the point at the time of framing charge. And despite also, again, my lord,
the liberty is granted to you. You await that liberty.
Let me terminate. On that case, my lord, I am telling High Court of Orissa, two cases can be registered. And that ground I have been directed, matter. In this case, I am telling because I am not the owner of the truck, nor I was traveling. How can I be charged with 43?
And that for a case, he has been acquitted, my lord.
I am on the ground that I was not traveling in the truck.
Though he has filed the copy, my lord.
I am not able to follow a single word what you are saying.
I am acquitted in the GMFC court, holding the GMFC hold, my lord, that I am not the owner of the truck. Number one. Nor I am the owner of the Kenduli. Then that
Kenduli is concerned, my lord. He has been acquitted that, my lord.
Yes,
so
I am not about the Kenduli. The fake number plate. Since I am not the owner of the truck, my lord, how can be alive?
What he says that it is not the owner of that vehicle.
Yes, that is the finding of the
GMFC. This court, my lord, directed him to raise all this point at the time of framing charge, my lord. Where is that?
Yes, I told you.
That is, my lord, with me, my lord. I have downloaded, my lord, with CRLC.
That order is not being challenged. That ownership.
You had earlier, 1 minute, you had earlier approached this court by filing CRLC.
Yes, on the ground of other ground matter. I have prayed that for same cause of action, two cases cannot run.
Where have you disclosed that?
I have mentioned that shall let the shall be called for matter. Now I'm sorry, my whole purpose of the lordship is that since I'm not the owner of the truck.
First of all, the impugn order which you have filed as annexed 2 is not legible at all. And nobody is able to read it.
Your lordship will give in time. I will file certified copy of
the file it.
Yes, 15 days time we will have
copy to the impugn order.
Yes, all right.
Let the petitioner file the fair copy of the impugn order. Along with that, the order passed in the earlier CRLMC filed by him.
And the case we call for another CRLMC.
Yes.
So that it will be very clear, madam.
Next slide. Okay.
May I please alert? Well, on the last occasion, on 26th February 2024, the Lordship directed the Additional Standing Council to take instruction why charge has not been framed. I have already obtained a certified copy of order sheet.
2013 cognizance is taken.
Yes.
Why charge is not framed? That's
but we have given the copy, my lord. I'll verify the I say that. Mr. Maharaj, my lord, dealing with this value.
Mr. Maharaj.
Where is Mr. Maharaj?
Who is some happened person in there.
Mr. Maharaj is not.
ତାଙ୍କ instruction ପାଇଁ ଥିଲା ସେ ତେଣୁ ଆଣିପାରିବେନି।
The idea is 2013 cognition. Nothing is progressing. If you are not interested in this person.
It has become a common matter.
ଆପଣ 2 ତାରିଖ ରଖ।
ଆଜ୍ଞା
2 ତାରିଖ ରଖନ୍ତୁ ଆସନ୍ତୁ ଡିସପ୍ଲେ 50 କରିବି 50 49 50 କରିବି
Time taken up together it's 69 who accused was
69 with 69 50 Adam 50 50
My lord, may I please? I'm from Kalahandi, 50, my lord. I'm from Kalahandi virtual code, my lord. Pardon me. I'm challenging the order dated 22 8/22 passed by the Landed Court Adhesion Bhavani Patna on city number 12 of 22.
What do you want? Cognizance order.
Yeah, I'm challenging the cognizance order, my lord.
Investigation is still on.
My lord.
Investigation is going on.
Yes, my lord.
Cognizance is taken. Okay.
Yeah, I'm my lord.
Cognizance is taken. Okay.
The fact that case there, both the party are intent to marriage. They are having conjugal sex between them. A child was born. By taking other dispute, the opposite party too has filed a FIR against the petitioner. So my lord, stay the position and
bring her. We will quash it. Bring her.
My lord.
When?
My lord, let the notice may be sent, my lord.
Simply issue notice.
Stay.
And they are married already.
Yeah, they are already married, my lord. A child was also born. From the a child is there, my lord.
420, 376, 376 also there. The when it comes for the petitioner submits that the petitioner or the opposite party number 2 is the wife of petitioner. Wife of petitioner. Due to misunderstanding, there is a child born out of the wedlock also. Due to misunderstanding, opposite party number 2 has filed the present FIR and there is likelihood of settlement. Issue notice to opposite party number 2, returnable answer.
My lord, stay of the proceeding has been stayed. I file a stay also.
76 towards 26 years, but wife and husband. When you got married?
They are married in 2019, my lord. 19, my lord.
Out of the wedlock, there is one son or daughter.
Yes, my lord. One son is born, my lord. Son is born, my lord. Born, already born, my lord.
Son or daughter?
Son, my lord.
Son. Okay. Here further proceeding is number 112 of 2022 corresponding to Bhavani Patna PS case number 258 of 2020. You bring them, we will class it, okay?
My lord.
If the injuries are found grievous, this shall not be given effect to.
Yes, ma'am. Injury found grievous.
Grievous.
That is this present case, my
Mother
lord.
matter, both are brother matter. I filed this for a
That's right,
proceeding.
taken.
Proceeding was on the ground of initial there was a talk of compromise there.
And you have to appear and
But now that is no chance. Therefore, I will try to surrender.
Susila Agrawal and all. Now, right on. By the order dated 11/8/2023, the coordinate bench, while allowing ABAPL number 7132 of 2023, admitted the petitioner on anticipatory bail. However, the concession of bail was subject to the verification of the injury report subject to the verification regarding the grievousness of the injury, regarding subject to the injuries found in the body of the injured to be grievous. Grievous. Concession was made subject to the verification of the nature of the injury. After investigation, it was found that the injuries are grievous in nature.
Investigation are going on. Investigation going on.
During the investigation, came to know that after investigation, during investigation, it came to light that the injuries inflicted by the petitioner on the victim are grievous in nature. Therefore, the petitioner has apprehension that the concession of bail granted to the petitioner by the coordinate bench may not inure to his benefit. Benefit. On that apprehension, he has filed the present petition seeking quashing of the entire proceedings. However, at the time of argument, he seeks withdrawal of this petition with a liberty to appear before the court below and seek appropriate remedy under law by relying upon the judgment of Susila Devi.
সেটা হবনি সেটা চার্জশিট হিন
That's
higher officer
ଏବେ ତ already ଅଛି ନା ଚାର୍ଜସିଟ୍ ଯେ ଫାଇଲ ସେତେବେଳେ ନେବେ ସୁଧିରା ଦେବୀ ଲୋକଙ୍କୁ ଏବେ now you are protected. Grievous injury ହଉ କଣ ପୋଲିସ ଆରେଷ୍ଟ କରିଦେବେ ନା କଣ? ଚାର୍ଜସିଟ୍ ଫାଇଲ ହେଲା ପରେ ହେବ ନା?
Surrender matter. Surrender. Only if first half, second half.
And avail remedy under law. Under law. He under instruction he submits that the petitioner shall surrender to the jurisdictional court on or before 20th April 24, and in the event any application is moved by the petitioner, the same shall be decided by the session
by the courts below
on the same day on its own merit.
17.
Adjourn.
37.
Adjourn.
42.
जो second call रिजल्ट होनी है, even after second call nobody appears in the interest of justice adjourn to July, sorry, May.
42.
Yes, 42. Nobody appears. Same, huh? Even after second call nobody appears in the interest of justice adjourn. Yes.
51.
May I please, sir? I am challenging you with your cognizance order under Annexure 4, my lord. Cognizance has been taken 376 to N 414
Yes.
323 506, my lord. I draw your paper going the merit of the I draw your attention annexure to the 164 statement of the victim, my lord.
Read it.
Lady. Second para, ମୁଁ ଏ କେସରେ ଥିଲା କରି ପୀଡ଼ିତ ମୁଁ ଏସିକ ମସିହାରେ ବାଲେଶ୍ୱରରେ ଘଟିଥିଲା 2000 ଭାରତ ଫାଇନାନ୍ସ କମ୍ପାନୀ ଆଇଟିଆଇ ଛକ ବାଲେଶ୍ୱରରେ ଚାକିରି କରୁଥିଲି
आराम से पढ़ो आराम से टिके पढ़ो स्लो 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 पढ़ो स्लो रे पढ़ो
ଘଟଣା 2016 ମସିହା ବାଲେଶ୍ୱରରେ ଘଟିଥିଲା ମୁଁ 2016ରେ ଭାରତ ଫାଇନାନ୍ସ କମ୍ପାନୀ ଆଇଟିଆଇ ଛକରେ ବାଲେଶ୍ୱରରେ ଚାକିରି କରୁଥିଲି ଈଶ୍ୱରଗିରି ମୋର ଟ୍ରେନର ଥିଲେ ସେ ମୋର ସିନିୟର ଥିଲେ ତେଣୁ
Today I'm appearing and filing my VNAMA also.
What is this case?
One petition proceeding, one annexure 1 is pending before the authority, executive magistrate Cuttack.
147.
Aye.
If this 147 proceeding is 22.
22 जो order sheet ଦେଇଛି ଖାଲି ଖାଲି ତାରିଖ પર ତାରିଖ ହଉଛି ଆଉ କିଛି ହଉନି ତାପରେ ସେଇ ଭିତରେ
I'll file my objection to
Objection, you tell me, I'll dispose it up. Is it 2022 matter?
let me request for a complete copy of the petition along with annex will be served to me.
expedite disposal ମୁଁ ସେଠି ଦେଇଦେବି expedite disposal ରେ କଣ
କପି ଟା ଗୋଟେ ଦିଅ ମୁଁ ଦେଖିବି ଟିକେ ମାନେ ମୁଁ ଟିକେ
expedite disposal ପାଇଁ
so that I can
ନୋଟିସ ଦେଇଥିଲୁ ପରା
ନାଇଁ ଖାଲି କପି annex ର ଆସିନି
ଆଉ କେମିତି କଥା ସବୁ ଜୀବନ ଜୀବନ କି
ଖାଲି
ସବୁ ନୋଟିସ ଗଲା
petition ଟା ଆସିଛି
ମୁଁ ଦେଇଦେବି ସାଙ୍ଗେ
ମୁଁ ପାସ୍ ଓଭର କରି ଏଣ୍ଟ୍ରି ନେଇ ଯାଉଛି ଦେଖିବି
ହଉ
I'll pass it over.
ମୁଁ ଦେଇଦେବି
At the end of
ସାଙ୍ଗେ
the board, I'll take.
no I'll take so little time I'll go through the
Later.
at least 7 days may kindly be given so that
The second week out of the. Okay.
55.
So enters appearance. File Wakalatnama have you filed, ma'am? Filed the Wakalatnama. It's taken on record on request. Yes. 50.
May I please allow? Yes. Well, this application is filed for passing of the entire criminal proceeding. Due to the weather, my lord, the informant is not able to come, for which we are not.
What
is the allegation under section 420?
Where are they?
Compromise.
They are from Bhubaneswar.
Bhubaneswar. Is working as the branch.
What is weather is about weather? Everything is closed or what?
He is using scooters for his.
Wasting time unnecessary.
So you lordship kindly keep it.
Bring them tomorrow.
Yes, madam.
Tomorrow morning, first class, first hour. Huh? Let them come.
Obliged.
What is your FIR is?
FIR is, my lord, annex 420, my lord.
Bring them.
Obliged.
Small matter, why are you keeping unnecessary?
Disposal.
Disposal, yes.
56. 56.
Even after second call, nobody appears in the interest of justice.
Well, that at 3 p.m.
Huh?
At 3 p.m.
3 p.m. Yes. 57.
57.
Yes. This serial is being held to oppose.
You are for?
For the petitioner. Petitioner is the informant of the case. His son is being injured.
What do you want?
I want the cancellation of the bail which was being granted without hearing. Though I am from SC/ST community, and the offense I was not heard during the when the bail was granted by learned additional session judge, and moreover the injury report was not procured before granting the bail to the.
Subsequently, injury report, my lord, the highly here, my lord. But in fact, one person appearing for the opposite party, my lord, whoever was granted, Mr. Bharatbhushan Rautra, my lord. He not there, my lord, not able to urgently.
Not yet present. Nobody appears for opposite party number 2.
Non-appearance of opposite.
59.
Opposite party number 2, nobody
Yes,
has.
is there, madam. 57.
Yes. Yes,
May I
tell me.
please your lordship?
1 minute, 1 minute.
Pardon. Perceive adjourned to item 57. I am for the opposite party, he is for the petitioner. Cancellation
Not-
bill they have filed.
Not so simple case, madam. Madam, kindly have a glance to the order sheet, madam. You'll have the
He is asking for cancellation on the
Yes.
on two ground apparently.
On the-
Whatever I understood.
Yes.
One is it is SC case.
That is not the ground.
He
Lord.
should have been hurt. Secondly, what he says is the injury report was not clear.
Not placed. And
That
after
is shooting on
after 5 months he was medical examined and on 5 months he found that the injury is grievous in nature.
No, not
Yes.
that manner, madam. On the relevant day, madam, when I was hospitalized, the IO has deliberately not taken care of that aspect and not also the Laner court. Although bail application was filed, on the same day, on the same next day, the first bail application was filed. On the next day, it was withdrawn. 2 days thereafter, bail application was filed, and after 4 to 5 days, it was posted for hearing. On the relevant day, the Laner court, without calling for the injury report, also has allowed the application. And at the relevant time, I was struggling for life, and at the documents which I have annexed, clearly shows that the injured was severely assaulted, and because of that, he was undergone surgery also, and recently also he is also with the same
Injury
condition.
report, calling injury report or not, this is a discretion. That's it.
No.
Whether in SC/ST case, whether is it necessary that
That is mandatory. That is mandatory.
mandatory provision is not
mandatory.
What is your answer?
But I also find objection. So for 360 Act concerned, in the FIR he has not made an allegation regarding the any assault of any 360 attracted Only he.
I'll simply say that I'm remanding it back to the court below to the application to be heard afresh on the basis of material available on record as of today by hearing you. Till then, this order will remain.
Yes, yes.
Okay?
Yes, sir.
Right on. The petitioner has challenged the order dated 13/2/2023 passed in BLAPL number 74 of 2023 by the additional corresponding to GR case number 85 of 2023, whereby the opposite party number 2 has been enlarged on bail. The petitioner being the informant, Mr. Chand appearing for the petitioner, oblique informant, submits that since in the case SC/ST offense under section SC/ST prevention of so-and-so act is involved, issuance of notice to the informant before grant of bail was mandatory. Secondly, the learned trial court, and even without calling for the injury report, has granted the anticipatory bail. Therefore, he seeks indulgence of this court for cancellation of the bail. Taking into consideration the peculiar facts of the present case, the impugn order dated 13/2/2023 passed by the additional sessions judge Talcher is set aside, and matter is remanded back to the remanded back for reconsideration of the bail application afresh by giving the opportunity to the
to both the parties.
Parties concerned, my lord.
Opposite party
The
by
petitioner.
giving opportunity to both the parties.
Yes, both parties.
Both the parties, and taking into consideration the materials available on record. Till the application is disposed of, the order granting bail by the learned sessions judge on 13/3/2023
Remain in
court.
13/2/23.
13/2/2023
Remain in force. Yes.
Enter accessory.
It is kind of an interim order.
Yes.
Yes, sir, no, Mr. And after 5 months, he's saying I have sustained grievous injury.
Say within a specific time frame, within 4 weeks or like that, it will be disposed of, because the things may linger because they are now we have to face the image.
No, the file application that will be notice will be issued to him.
The learned trial court is expected to dispose of the application
Expediently.
fresh and expeditiously
Yes,
possible.
And on production of a certified copy, the order court, or my lord may direct the
Oh, it will go.
order to be communicated to the master court below. My lord may direct so.
The
Order be communicated
order
to the
may be communicated to the
fourth
court
week.
below.
Fourth week.
Yes.
59.
May I please your lordship?
Yes.
It is an application under section 482 CRPC.
Application?
482 CRPC.
Oh, yes.
Yes.
What do you want?
Sir, I want to set aside the impugned order dated 15th April 2021, passed by the learned first DJ com ASC Raurkela in criminal appeal number 7/21. By directing the opposite party, yes.
What is this order? Is the 15th?
Sir,
By
the
this
order, the order is limited. The order has limited the order of maintenance from the date of since the date of order to the date of decree of divorce, up to the decree of divorce.
You want it is from the date of application?
Yes, sir.
I simply issue notice. Issue notice to you.
The notice has already been served.
Sir.
Yes, sir. Notice has already been served, sir.
Where is notice was never issued?
So notice gone on 29th February 2023. And it is sufficient, sir. Service is sufficient.
Order 3 to 23. Service? Service complete. It is issued. Up to the license.
One 323.
23.
23. 19/3/23.
19/3/23. 19/3/23, na? But the last date 19/3. Matter was listed on 1/3. Tapar date service. Tapar service, na? 1/3/2023 the last date period.
Sir, 1/3/23 ରୁ ଆଜି ପର୍ଯ୍ୟନ୍ତ ପେଣ୍ଡିଂ ଅଛି.
See, and when the last date of hearing is 1/3/23.
Yes, sir. Yes.
And
Yes, my
thereafter
lord.
on 19th of March, the service is complete.
Yes.
So after service, this is the first date of hearing. Okay, let us wait. Somebody may come.
Service. 21st February 23.
So therefore,
23, sir. 2023.
the service on the opposite party number 2 is complete. Despite service, nobody has appeared. In the interest of justice, urgent to second.
My lord.
Second week, I'm keeping it in second week because it was served on the opposite party little late. Somebody
My
may
lord,
come.
please we direct the specific date so that.
Yes, yes, 15th April.
Yes.
Item 60.
Nobody else.
61.
May I please, Your Lordship?
61 will have kindly
Ma-
pass over.
Ma- Your Lordship may hear me, my learned friend Mr. Mishra may come.
HS Mishra
That
will
was just
actually
let me
discuss.
clarify, my lord. He is the informant, he has to assist through the prosecution. Your Lordship has been pleased to call for the entire record, it is before Your Lordship. Your Lordship will peruse and decide my fate. I am to also just assist with reference to the record, nothing beyond that. Let him senior come.
5 to 10.
I'm assisting, it will take me 5 minutes also.
Continue if you come.
My lord.
75
Well.
84 ତାଙ୍କର ଅଛି sir.
हाँ, सारी क्या सुन दो, I am assisting your lordship, my lord. But here is a case, no, that is because, my lord, your lordship knows, your lordship has been pleased to allow enough indulgence to the informant to take time in this case. Your lordship remembers, my lord, he wanted the documents to be.
Who is appearing for?
Let me not again
Sir,
take
HS
the name.
Mishra,
My lord, should put name,
Mr. HS Mishra.
Particularly.
Oh, that is the
Dora
matter.
Love.
That matter.
I am having little fear
They are
psychosis, so I am unable to take the name also.
Okay.
Sorry, ସେ ଆସିଲେ
ମୁଁ କରୁଛି ପ୍ରେଜେଣ୍ଟ କରୁଛି ଆସିଷ୍ଟ କରୁଛି let him come let him come
Mr. Mishra wants that peacefully he want to argue.
My lord,
You want to argue peacefully.
No, I'll just ask, I'll just ask. But there is a,
In the absence of the.
no, let me just, I was telling I was telling my friend, I have also nothing personal for this case is concerned. I have always, all through my career, behaved like that. And he agreed to that also. I'm just conducting a case, that's all, assisting your lordship. Your lordship will decide the fate. So there is nothing to be.
Don't identify yourself with
Exactly.
particular brief.
That is what I was telling my friend.
Matter comes, matter goes.
Just before the case was taken up, I had a, if your lordship, if your lordship permits me in typical Katki language, I had a khati with my friend. I was telling him that he agreed. He said, yes, Bhaina, you never get attached to a case. So I have nothing here. I'm just, I'm doing it. That's all.
Yes.
Let me just. Class ठीक अच्छी. I'm waiting if your lordship. So let us do it peacefully. एतरे किछि नाही.
One more issue, why to?
तापरे मु ए कोर्ट रु गला बेले स्ट्रेस हे जिबा चाहुनी for some reasons. मु I don't.
Nothing will happen. Don't.
Because मोते लागे भल लागे नहीं आया.
The climate is good today.
I don't want to be stressed for a case.
Yes. There are two matters, huh? You have to.
And I am stress free because I never say anything to my client before the case. I say only I will conduct the case. Therefore, you are engaging me. So when I don't say anything beyond that, I remain mentally very free.
That's fine. Yes.
62.
Item 62, I am appearing for the opposite party complainant Millers.
Yes.
My lords. And in this case, Millers, the matter relates to a 138 enact proceeding Millers. By the order debtors.
You are for the petitioner.
I am for the OP, my lords. OP. The last occasion also he non-appeared, my lords. And my miscase for vacation of stay is pending. Of course, that since
right on the last date of hearing on 3/10, interim order is passed on.
interim order passed on 16/2/2023.
Right on.
And I appeared
16/2/2023.
Yes.
While issuing notice to the petition opposite party, interim order staying the further proceeding, isn't it?
Yes, your lordship.
Staying the further proceeding in ICC case number 34 of 2022 was passed. After notice, the opposite party number 2, opposite party has entered appeal. When the matter was taken up on 3/10/2023, none appeared for the petitioner. Therefore, in the interest of justice, matter was further adjourned. Today, when the matter is again called up, nobody appears for the petition. The present case is arising out of a 138 proceeding.
Yes, your lordship.
Arising out of a proceeding under section 138 NIA. Petitioner is the accused in this case. The complainant submits that because of the pendency of this case, his complaint case, namely 1CC case number 213 of 2020, is unnecessarily prolonged. Taking into consideration the aforementioned facts, the criminal miscellaneous petition is dismissed.
And interim order may be vacated, my lords.
Main petition I have dismissed, everything gone. Main petition I have dismissed.
My lords, learned court below maybe your lordship kindly clarify. I originally the interim order.
I have dismissed the main petition. Where is the question of interim order? Interim order, and don't you know the principle of merger?
Yes, that is true.
Yes.
63. My lord, matter has been compromised, my lord. Matter has been compromised, my lord. Last occasion, your lordship directed to appear accused person, my lord. Accused person is present before this court.
What about the?
My lord, opposite already in appear, my lord.
Her personal are dispensed with by last time. That is on 15/3. She stated that she has already taken the money. Relax.
Right on. The matter was taken up for hearing on 15/3/2024, and the following order was passed. Following order was passed. Since the petitioners, that is Kishore Chandra Jana, Devanti Nai, since the petitioners had not appeared on the last date of hearing, the matter was adjourned. Opposite party number 2 had already appeared before and filed the necessary affidavit and made a statement that she doesn't want to proceed against the petition. Therefore, a detailed order was passed on the last date of hearing. The petitioners are present today in the court in person and also represented by their counsel who identified them. They filed a self-attested copy of their Aadhaar card, which is taken on record. Aadhaar card to establish their identity, which is taken on record. And both the petitioners conjointly praised that the FIR registered against them by the opposite party number 2 may be quashed on the ground of settlement. The Ragada appeals from the state and submits that in view of the order passed in last hearing and in view of the fact that the petitioners have appeared before the court in person, indulgence may be given to the petitioners. Taking into consideration also, FIR also continues to cost. But
64.
Under 64, I am for the petitioner. My learned friend is for the opposite party. That's he has served the copy of that affidavit, reply affidavit to me. So I want to make a short.
No, my lord. I object. In this case, my lord, although I never object.
When have you supplied?
He supplied on 13th. 13th supplied.
Supplied, my lord.
What is this case?
My lord, this is a case where a standing order of this honorable court is existing, my lord. A revision order passed by single judge of the courted bench of this honorable court.
With regard to date of application, so whether the interim maintenance is to be granted from the date of application of the filing of interim application under section 23 of the DB Act, or from the date of filing of the section 12 of the DB Act. That is the case,
my lord. That
what is the position?
Here, what has happened, so here the learned court below, the learned magistrate granted interim maintenance from the date of filing of the DB, that is section 12 of application, but not on 23. That is my case.
Not on
23 application. When he filed it, she filed the 23 application. From that day, she will get the. She is entitled to the
difference.
Difference is 3 years.
That
3
is
years.
not the question,
15 from
the law.
Law is Rajnas versus law says from the date of application. That of interim application.
Let me Mahapatra also be
No, that is there. He knows matters. He Rajnas versus no idea.
Then I will.
Yes, my lord. Your lordship.
So my responsibility is my lordship may take the matters from other day so that I'll
This is the issue. Will.
Yes, my lord.
My lord, because he has supplied the copy, I must go through.
Don't go on the facts. The facts are admitted.
Facts are
admitted.
And this court.
Forget about that. You tell me the position of law.
My lord.
You have a judgment. Give me.
Yes.
My lord, before going into that judgment, my lord, the lordship may just come to their list of dates and events.
I am not on that. He is also not disputing the fact.
My lord, a revision, my lord, what has happened in this case, if my lord permits me, I'll enlighten my lords. My lord, there was an order passed by learned SDJM in CMC number 451 of 2015, in which he has preferred an appeal before the district court. The district court has merged the maintenance awarded in the DV Act under 23 and my lord, in the maintenance awarded under 125, my lord, and has passed an order for paying maintenance of rupees 14,000. Again, the petitioner has approached this honorable court in CRL REV number, my lord.
It's all right. Number, forget.
My lord, he has approached in the criminal revision. Taking Rajnesh versus Neha into account, the revisional court, my lord, has merged the order of the district judge along with my lord, set aside the order of the district judge and merged the order of the family court along with my lord, the order passed by the.
When that 125
My lord,
125 proceeding.
my lord, 125 proceeding is not challenging.
I know, I understand
My
what
lord.
you are saying, but since the dates of 23 petition
My
and
lord.
12 petition and 125 petition.
12 and 23, my lord, his contention was with regard to whether the maintenance has to be awarded from the date of application, the primary application that is under section 12, or from the date of interim application. My lord, to that effect, the position of law is very clear. That it has to be from the date of application, but it has not clarified that from which application. That has been laid down in paragraph 109 in the judgment of 2021 to SEC 324. This is settled, my lord. This court may have exercised its power under 482 for my lord dealing that issue.
What is the differential amount?
Matters differential matters many because 3 years gap, there is 15 10,000 टंका लखे हेले 3 लाख 4 लाख बाकी पे क्या
50% दें तो काम खत्म हो.
My lord, standing order is present, prevailing, my lord.
My assumption is
revision order. Your lordship may just hold my reply affidavit. The lordship may just.
The moment you read your reply affidavit, he's entitled to sign. He's asking for.
My lord, without touching that even, my lord, the order passed by this honorable, which he has although mentioned in the date and events, but the same has not been annexed.
Neha Bala judgment.
2021 to SEC 324.
Yes.
My lord, 109.
Para that
109.
final lesson subpara VI that towards the last minutes. That is D. Date from which maintenance is to be awarded. We make it clear that the maintenance in all cases will be awarded from the date of filing of the application for maintenance. That is
for maintenance.
Yes, madam. Application for maintenance.
My lord,
as held in para B, IV above.
My lord, 2021 to SEC 324 judgment, if my lord holds paragraph 109, it clarifies that from the date of application, the
that is further clarified in Neha.
My lord, Neha judgment only I am relying.
For maintenance.
My lord, Neha judgment only I am relying. On which citation my lord, senior is, that is SEC.
You might be holding another book.
My lord, SEC citation he rely korchi.
And the words which are which is not in your interest, you must be not visible to you.
Yes. My lord, to that effect, if the question ought to have been, my lord, I would not have disputed.
The date of application for maintenance.
Yes.
Then it is section 12 application.
Yes. Section 23.
Section 23, my lord.
23 application.
Yes, my lord. If that would have been the case, my lord, I would not have objected, my lord.
You
But
read the judgment and tell me.
my lord, that only I am submitting, my lord. And in the meantime, my lord, the petitioner has obtained a stay order. Your lordship may hold that order, my lord, in which he was directed to pay the maintenance award as directed by the family court, my lord.
Oh, so he will keep on paying that.
My lord, family court order has been already merged as
subject to, write down, subject to the petitioner continuing paying the interim maintenance awarded to by family court.
No, my lord, the family court order has already been merged in the CRL REV order, my lord. That is my case. That has been merged, my lord.
The interim, Mr. Acharya, it's time to revert on the revert to the counter filed by the opposite party. The interim order passed on such date. Interim order passed on 9/1/2024. We continue to list it up with a modification that the subject to the petitioner continuing paying the maintenance
as awarded
by the courts below. The impugn order.
Means that 10,000.
10,000.
Keep on paying the country
as awarded
regular maintenance.
As awarded by the revisional court.
Regular maintenance, courts below.
My lord, obliged.
Right.
Obliged, madam.
That area 3 lakh rupees will.
That may be state, madam. I do not know.
वो एरिया से देखिए सब स्टेटमेंट लगा देखिए भी दिनो अधिक से नहीं
Yes, next.
ଏଇଟା ସେଇଥିପାଇଁ ସାର୍ ମୁଁ କହୁଥିଲି କଣ କି ଯଦି 6,000 ଟଙ୍କା ଦେଲେ ଠିକ ହବ କାହିଁକି
My
ନା
lord, this
ଅଧିକ
is on the
ଯାହା-
my lord, on maintainability, I am challenging, my lord.
already she has taken more than the
Those
If-
That
those
cannot be
calculations
entertained,
I'm
my
not
lord.
going to do it.
That
ଆଜ୍ଞା।
I'm on maintainability, my lord.
Urgent.
Urgent.
You wanted to continue with this modification.
My lord, posted to oblige, sir.
66.
May I please lose, my lord. On behalf of both, my lord. Here we got the certified copy of the charge sheet. Took some time to file, my lord.
68.
Yes.
Hmm? 68.
67 exam. 68.
61. Item 68 is last occasion government will take instruction for the CD.
Meantime, the proceeding of your case. Yes. Opposite party number 2, serving.
Order. Yeah, sufficient.
Yes, yes, Mr. Gowda.
Another CD has not come, my lord. Another date may given.
I have not called for CD. Where
My
are
lord,
they?
12/2, my lord.
Hmm?
While issuing notice, my lord, we call for urgently matter to 20th today.
But where have we said CD? If you notice opposite party, so and so it will be taken notice. Mr. Ragada is appearing for the and waves notice. I have not said only instruction you get. Okay, simply urgent Mr. Ragada seeks further time to take instruction. It is the matter of interim order to continue. Okay. Yes.
69 and 49 will be taken together.
69
and 49. 69 and 49.
Wait, please, my lord.
What are these matters?
My lord, this is a matter where cognizance of offense under Section 4 of the PMLA Act has been taken by a court which has no jurisdiction. This matter was investigated by the police and police submitted charge sheet, including offense under Section 4 of the PMLA Act. Whereas, my lord, there's a clear bar that the police cannot investigate offenses under the PMLA Act. No ECIR was ever registered. ED never commenced the investigation. Malads may see, I filed an additional affidavit.
Where in this 69?
Malads.
Yes.
69.
My 49 is similar.
FIR was lodged in which police station?
Malads, FIR was lodged.
Lodged on 420, 434.
Yes,
34,
Malads.
IPC.
Malads.
And after investigation, PMLA is involved.
Police has in charge sheet
and cognizance is taken.
and cognizance is taken.
Yes, who is appealing? Yes, how do you do that?
No, I am not. It is not a party.
ED is not a party.
It is not party. How can you file a charge sheet in the PMLA? You have no authority.
But after some
And court also taking cognizance.
But after taking cognizance, the file may not transmitted to the competent court, my lord. Since the
But you could not have entered into that arena at all. There is a direct bar.
My lord, that is the bar, my lord. For that reason, my lord, the court below, my lord, under STM Banki sent the file to the competent court, my lord.
For what?
For after some said
the investigation only.
What
If investigation is initiated, what to do?
My lords may kindly look at the additional affidavit which I have filed on the.
What happened in this case, my lord? There are two matters, my lord. Item of 49, my lord. I have misplaced that file, but second copy I have obtained, my lord. And take down them to my lord, both the cases.
My lord, I am in item number 49.
This
This is, my
There
lord,
what
both
happened?
matter are arise from the same case report.
Did I arrange one case, my lord?
Two accused.
Two accused.
Two alag.
They have
Issue is same.
Issue is same, Malads. Malads on
I am reserving the judgment. You
Day after tomorrow,
My lord, my humble
Day
submission
after
is.
tomorrow. Take very well. Day after tomorrow. बहुत
Again,
खाली-
previously the state has taken many dates to obtain obstruction.
What happened, Mr. Maharaj, my lord,
My lord.
instruction in the.
Keep it day after tomorrow. We'll see.
My lord, my
Yeah.
humble submission is, my lord, in spite of lack of the jurisdictions, Honorable
Sorry,
JNFC
sir.
Ginka has proceed this case and issue NBW against.
I have
Yes, sir.
stayed the proceeding, na?
Yes, my lord. So proceeding are state.
During the remain in stay proceeding, during the stay it remain, JMFC Ginka used to issue NBW against me. I am serious in prejudice, my lord. Kindly stay. I have also filed IA number.
In your case, there is no stay.
No, in my case, there is no stay, but IA is pending, sir. Kindly, in my case, stay.
If there is a stay, why should the court will do it? Well, let's see, 49, huh?
Ji.
Bank
IA is there, sir.
The banking. Banking piece kya? Abhi नहीं क्या सर?
49 tag करो.
Where
is the stay?
49 कौन सी?
49 there is no stay. In 49 there is no stay.
Ji. IA is.
So further proceeding is voting item 49. Further proceeding, in so stay.
Actually, I have also filed this jump for bail in this.
Further proceeding has stay.
My lord.
As per your 49 पे further proceeding stay करो, time interim order continue करो. ठीक है? Please on there. Both the matters.
Obliged.
Thank you, sir.
Deeply obliged.
Both the matters, just check it up. We will
dispose of.
Yes.
70.
Item 70, may I please, Your Lordship? Your Lordship, the matter was referred to the mediation center by Your Lordship, and the mediation succeeded. On the last occasion, Your Lordship had directed to place the other, Your Lordship, the petitioner, the opposite party had agreed to withdraw both the FIRs. On the last occasion, Your Lordship had directed me to place the old FIR as well for the quashing of the same, Your Lordship. However, I have not been able to trace the FIR, Your Lordship. It's of 2013, but they say that the FIR is only the FIR was filed. After that, no charge sheet was filed or nothing, and they are saying that it's untraceable at this moment. I pray that, Your Lordship, the present case that has been challenged, the present FIR that has been challenged in the CLMC may be proceeded. Yes, Your Lordship. Whenever I trace, Your Lordship, I may be allowed.
One thing, Your Lordship. Your Lordship, kindly for a moment, Your Lordship, see the mediation report, Your Lordship. In the mediation,
Sorry. What happened in mediation report?
Mediation is successful, Your Lordship. Your Lordship has sent
Then
it.
what are you?
Your Lordship may kindly see the mediation report. In mediation report 20th of February.
What do you want?
I have no objection if Your Lordship disposes of the matter. Only difficulty is that Your Lordship may kindly see point number 5. There is that on the last occasion Your Lordship said. Yes, Your Lordship. The original signed settlement deed.
He will file it.
That only Your Lordship observed. I have no objection.
I will take this report into the order itself. And then what? By order dated by order dated 5/2/2024, this court relegated the party to the mediation center for the purpose of settlement. The petitioners, the parties have undergone the rigors of mediation process and successfully settled their dispute. And the mediation center, by its report dated 21/2/2024, has placed on record
20th of February.
21/2/2024 has placed on record the mediation report, enclosing the mediation report dated 20th February 2024. The mediation report, the terms of the settlement reflected in the mediation report maybe made are taken on record and made part of the present order. Parties are parties have undertaken to comply with the terms of the settlement to its letter and spirit without fee, taking into account taking into account
Only one
the
small prayer, my lord.
statement made at the bar, and in view of the successful mediation which is taken on record, the FIR so and so is gone.
Only one prayer, my lord. This case is posted to 28th of this month, your lordship. That your lordship may kindly, my submission may be recorded.
Which one?
This civil suit.
Why are you trying to complicate? I am saying that you have to go.
My lord, your lordship may kindly
You
consider.
doubt the mediation report?
No, my lord, I have voluntarily agreed.
It's all right.
I only pray that let this be filed in the court. That is my only
I have taken that into the court's record now.
My lord.
This is a part of.
And in the civil court, it is posted to 28th of this month. My submission may be recorded, your lordship. That will help.
I
Let
don't understand, Mr. Mishra.
My lord. That's a submission before your lord.
Are you doubting that date? Why should I write?
That is there with them. So that is the difficulty, your lordship. Let
They
it
will
come.
give, they are bound by the mediation. They will give. Let's say that I will not give.
My lord. That is
Why
there.
are you doubting?
No,
We have settled the dispute, everything. You
My lord.
have little faith. If they don't do it, I make part of it. Then you file a contempt.
Yes, your lordship.
What is the big deal?
My lord.
Both the cases. Both the cases. Okay. In terms of the settlement.
Your Lordship, the FIR is the part of CLMC number 2830 of 2023.
Both the petitions are allowed FIR so and so. Would the common order.
Your Lordship, both the petitions cannot be allowed. Your Lordship, the petition my learned senior had filed it was for further investigation in the matter. I had filed for the questioning of the FIR.
Which one is yours?
CLMC 2830 of 2023. That is
2830 is allowed.
Yes, sir.
FIR is was 2830. And 4920 is
disposed of
in terms of the settlement.
Obliged.
71. Well, I may be pardoned. Item 69, which is being kept for day after tomorrow, can it be kept on Monday? Well, if it is Monday. Let's if a particular, let's be keep it at 2 p.m. on day after tomorrow. If it's
We don't know 2 p.m. The court will function or not function. I don't know. Let it be after first week of. So many ifs and buts, then.
No, let's ask support.
Second.
No, let's ask support. No, I take back my.
I want to do it as early as possible. You don't want that.
No.
Yes.
71.
Yes.
72.
May I please, your lordship? Here, my lord, the petition last occasion, my lord, plead to issue notice.
I am for the opposite part number 2, my lord. Here the petitioner has challenged the order of cognizance, which is I raised the question of maintainability, my lord. It is revisable. It cannot be under 480.
Cognizance order.
Cognizance order.
Here is a case, my lord. Though revisable, but it can be, my lord, challenged under 482 because, my lord, the ingredients of the offences are not made out. And
But why cognizance says the court should interfere?
Yes, my lord, I am coming. Here is a case, my lord. The petitioner number 1 initially instituted a case, my lord, that is annexure, my lord, 2, running page 22. That, my lord, pertaining offence 376(2)(3) and, my lord, 313 and other allied offences against the, my lord, son of the, my lord, OP number 2, my lord. Then, my lord, this case, my lord, after throughout investigation, they, my lord, arrested or some religion bail and charges submitted. I am the, my lord, prosecutor of the, I am a victim of a 376 case. And one thing, and in my lord, fine, protest petition, he developed his story, whether that maintainable or not on that point. I am saying
You understood from the beginning. Why are you wasting time? You took half an hour only to be. That is the reason I have passed this order. You have a good case. argue that at the charge case.
Charge number.
Fantastic case you have, I'll tell you. Concentrate and argue.
No, that's out.
Fantastic case, you definitely will be discharged. Definitely will be discharged. And you only argue.
27
Don't send your junior, you are.
No, Milord, I am playing 27. ମୁଁ ଗୋଟେ ଖାଲି ଗୋଟେ written note ଦେଇ judgment ଦେଇ my lord pass
ମୁଁ
appropriate.
judgment reserve ରଖୁଛି ଆପଣ ପଠେଇ ଦିଅ ଠିକ ଅଛି because I have wasted lot of time please
Including the 161 of that.
whatever you want. Judgment reserve 73 yes. But judgment reserve is another danger. In a cognizance says I have to write something, then it is that is also another thing.
Yes, Milord.
So therefore, better that you, why don't you argue people? I am giving you full liberty. I'll write the full liberty I am giving you. Better that you argue. Why do you prejudice your?
27 ତାରିଖରୁ ସେଇଦିନ ଉଡ୍ର କରିଦେବି ମୁଁ ତ ବୁଝିଲି 205 ରେ ଯାଇଛନ୍ତି କି ବେଲ୍ ରେ ଅଛନ୍ତି ନାହିଁ ମୁଁ ଟିକେ ବୁଝିଲି ଖାଲି ଷ୍ଟେ ଅର୍ଡରଟା ଏଠି ଥିଲା ସେଇଥିପାଇଁ କହୁଛି ମୁଁ କମ୍ପ୍ଲିଟ ଇନଫର୍ମେସନ ନେଇଗଲି ଯଦି 27 ତାରିଖ ମିଳିବ ଥାଉ ସେଇଦିନ ଉଡ୍ର କରିଦେବି ଯଦି 205 ବି ଥିବ 27 ତାରିଖ 27
73 କେତେ ମିନିଟ
Dita CLMC ଆଉ ତିନିଟା revision
revision yes
challenging the order dated 21/9/2023. That is a cognizance order. The case, my lord, that it is arising out of a complaint case.
Complaint.
My lord. Your lordship, and have a glance to the law and code below has two cognizance under
What are the offenses?
498.
498.
My lord.
Yes.
Your lordship can have a glance to the 202 inquiry held by the.
Who is appearing for opposite party?
I am appearing for.
Yes. Is there any chance of settlement?
No.
Why
Perhaps
don't you
not.
explore the chance of-
There is no chance of settlement. If your lordship go through.
Why is it?
Because, my lord, he is an outsider. He is a friend of my husband. Taking the debt and deceived me, abducted me from Cuttack to Puri, returned there and left me.
25 years.
My lord, your lordship can have a glance to his statement. I am relying on her statement. Your lordship, annexure 2,
Yes.
page 26. May I read, madam?
Yes, sir.
My husband, namely Panchanana Kanna, training
Relevant part you read.
relevant part, my lord. Page para 6, madam. Next page, 27. On 15/5/2023. Lordship got it.
Accused asked me to.
Madam, the accused asked me to accompany him to market to purchase a sari for his mother. So I asked my sister-in-law to look after my son and went with the accused. However, the accused, in spite of shopping, took me to Sai Siddhi Lodge at Puri in the name of some urgent work. We stayed in the night there, and that night he asked me to pay 5 lakhs from my father for purchasing a car. I asked him why he was demanding money if he really loved me, but he did not answer. The next morning I woke up and found he had fled away. I tried to calling him phone, but he had blocked me. He has paid the hotel fees at 6 a.m. in the morning and left. So what offense I have committed? What, as per 490, the London magistrate has taken cognizance under section 490.
Where is the cognizance order?
My lord, page 25, annexure 1.
Yes, sir.
The case is put to the advert for Hajira, hard on the point of cognizance, peruse the complaint petition, initial statement, and I am prima facie satisfied this case is under section 416 and 498 of IPC. And if your lordship go through the 498 relevant section, my lord, 498, with the intent of criminal. Criminal. ସେଇ ଗୋଟେ କଣ ହେଇଥିବ ପଢିଲା ଟିକେ May I read my 416? Your lordship, may I, for my satisfaction I am reading.
For you are not your satisfaction. Satisfaction on the statute.
Yes, my lord.
Why do you ask me why?
No, no, sorry.
How do I know?
No, no, sorry.
The
That
evidence is that nobody.
no, no, no. Evidence is, my lord. She accompanied me to Puri.
Read the provision.
Yes, my lord. I am reading. Whoever takes or entices
And
any.
that's a matter of trial. You have, whether you entice or your intention is to take
No, no, no.
extract money on all these things. 5 lakhs you have taken her. You took her. She says that you asked her to accompanying her to go for purchasing sari.
Yes.
You took her to somewhere else.
Yes.
Kept her whole night.
Yes.
And thereafter you asked for 5 lakh rupees.
Yes.
What else is needed?
No, my lord.
498.
498, may I read, my lord? Whoever takes or enters away
And
any
the
woman.
thing is clear because you have taken for some pretext and taken.
No, no, no. That.
No will not.
My
make
lord,
no, sir.
my lord,
No
it
will not
from
make no.
your lordship from the very statement, my lord, your lordship can have a glance to what 416 and 498 with a my lord, your lordship with a intent that my lord, that is the very with a intent that she may have intercourse with any person or conceal or detains with that intent any such person shall be move. Where is my lord? There is a detention. I have not detained him. He has accompanied me
All these things
and resided.
all these
If
things.
if your lordship go to the
Only prima facie.
not it is not a after taking cognizance prima facie your lordship. If your lordship gone through the complaint petition and the 202 inquiry, my lord, he has stated he accompanied me to Puri. They both resided. My lord, I have not asked him, detain her, or asked only 5 lakhs. Only for purchasing a car. Then when I asked him why he was.
Then wrong charge, according to you.
Wrong cognizance, my lord. No offense is made out, my lord.
Then you argue at charge stage. If you are so keen to argue.
498.
It's, according to me, madam.
Then, my lord, I will show decision, my lord. Your lordship,
Challenges.
my lord, pardon, my lord. Your lordship, keep it to tomorrow. I will show you some decision.
We are unnecessarily wasting at the.
No, my lord, no. It is not a unnecessary case, my lord. It is a very good case, according to me, not for your lordships.
According to you,
my lord,
majority prevails. According to both of us, not good. 2 versus 1.
My lord, it is a very good case.
Majority
there is no intention. If my intention, my lord, to confine her, to have a
See, sir, in a the cognizance says prima facie has to be seen. The veracity of the evidence is not to.
It is no privacy is made out, my lord. Here he has stated that she accompanied me. Went to Puri.
And your argument may be good at the stage of framing of charges. May be good. I'm not saying that you don't have a case. You have a case. But at the stage of charges, obviously you can say that this charge is not made out or that charge is not made out. But in a cognizant stage, you want me to,
no case is made out, my lord. If you are go through the, my lord,
you will be discharged. Completely discharged. What is wrong in it? You will be discharged. I will give that liberty to you. Argue on elaborately. Why do you invite some observation at this stage? It may prejudice you. Therefore, I am saying. You think over. I will give that. I will record your statement and I will reproduce this paragraph also. I will reproduce that paragraph so that it will be easy, right out. The petitioner is challenging the order dated so and so. Order dated 21/9/2023, passed by Leonard JMFC 2 Kotak in ICC case number 80/2023. Land Council, Mr. Ajajia, Land Council for, sorry, I'm so sorry. Mr. Mishra, Land Council for the petitioner submits that the reading of the complaint case coupled with the statement recorded under section 200. 200 statement of the complaint either 498 or 416 of CRPC. He supply emphasis to the statement of the complainant, state of the complainant recorded on, where is that? Recorded on, where is that?
Last minute.
Hmm.
Annexed to 12/9/2026.
Yes. Recorded on
12/9/2026.
26. What is that?
12/9/26 annexed.
26. Particularly para 6. Para 6, 27 para 6. Para 6. Relying upon the aforementioned statement, he says that the ingredient under section 498 or 416, no ingredient under 400 provision is made out from the facts of this facts of this case. I'm not inclined to interfere at this stage because the court below has only taken cognizance for the offence under section 498 oblique 416 CRPC. However, liberty is granted to the petitioner to argue the aforementioned point apart from the besides the other point at the time of framing of charge, and if by moving appropriate application, if any such application is moved by the petitioner before the trial court, the same shall be considered on its own merit.
At this stage of charge.
At this stage of charge, you move an application.
So far as my it is tribal magistrate, my lord. So there is no framing of provision of.
You move an application, therefore I said.
Yes.
Such application is moved, then I know that framing of charge. So that's the reason I said publicly. If such application is moved, and it will be decided. Right, disposal. Yes. Anybody is there for any revision matter? And that no. There are 75, 76 or 77. Revision, yes.
79.
Are you ready?
75, 6 or 7.
No, revision. Only the revision petition 75, 76, 77. Anybody is there?
76 next week.
So everybody is asking for time.
Same day, 28.
So 28. 28. Yes. Next. 3 o'clock on Met.
And 61.
It's not fixed. 74 is the next matter. It's not fixed.
Yes. 74. What happened in this?
74 we mentioned before the Honorable Chief Justice. He has assigned both the matters here. Both matters have come before. Yes.
Yes.
Both matters have come. Now it will almost complete 4 months in this country. So your lordships may.
Another 10-15 days for
My lord.
My lord, apart from this, lordship may also peruse the order of the honorable singles as regard admitted suit is concerned. On that order, I think my learned friend submitted the same, and there is a order of arrest of this chief.
That admiral
suit.
That is what
They are not
what we
included the
have to
party in
examine.
spite of this order. Judicial order is there.
What is the impact of the arrest order in admiral suit on this revision? That is only.
No. Not only this, they have filed revision. We are filed purity application. Sorry, they are filed purity. We have filed it. That is assigned to other base. Unmentioned, it is come to my level because it is better to analyze both the cases to be heard. Sole point is that they are claiming that the SIF is value of such and such. So the particular amount determined by the court below should be reduced or it may be modified.
Right.
Our submission before is that twofold prayer we have come to the court. First prayer is that they have impeded the state. State is a party different to our superintendent of customs. It is wrong because without hearing us, they have passed an order. Second point we have is that they have assessed the value of insurance company. Basing on that, they determine the value of the vessel. We have said that
100 crores and 10 crores
and 10 crores of this value.
Sufficient.
Yes. So they are praying that this whatever 100 crores and 10 crores should be modified to the extent what lordship will decide on the merits. But our submission will be that the vessel, this order passed by the court below is primarily wrong because this vessel assessment, what amount they have done, basing on the insurance value, is not correct. and that order may not be modified to the extent because it should be quashed. This is our.
No, it needs to be heard.
Yes.
I'll just surprise my lords. 451 application was filed before the concerned court. The court has allowed subject to certain conditions.
I know the fact.
Yes.
There is not
So
a.
Admiralty matter I had explained, my lords, that the coordinate bench, the designated judge is in Cecil. My lord had said that that's an independent case. These both have to be disposed of together. So
insofar as the criminal miscellaneous case is against that
condition,
and the main revision is against the main order.
my lord.
The revision has to be heard.
My lord.
Revision has to be heard.
Now, my lord, it's only against release.
I know.
Whether release is to be granted or not. I had shown.
Release with condition or without condition.
My lord.
Will
My lord, the division bench order says that 2 weeks is the vehicles this ship without being.
What I am clear, my lord, if lordship will go to one step ahead, lordship may issue notice to both the parties because we have appeared and they are appearing in this
okay,
case.
also
Also,
file
yes.
your respective pleadings.
Yes. Then it can be complete and lordship may find necessary.
File and give a date. देखिए दे दो 10th of April. Yes.
10th April, my lord. In fact, it's a revision. And the revision normally no counter is filed.
Board is so heavy. What to do?
Our precarious.
Still, I'll try. I'll sit with him. Just see.
Then let it be the first week of April. All that.
You don't
only lordship keep it. Only may not be in fourth. Fourth, I have some.
Not fourth, but he will try to accommodate.
10th is fine.
Mr. Mitra, just give some. Yes, so that
And can I request that it be taken up at a specified time? It's only
time
that
3 o'clock.
3 o'clock.
Because miscellaneous matter I'll be here.
Yes.
Yes.
3 p.m. is compatible. Yes.
3, then 5th, may I request? 5th.
3 o'clock. 3 o'clock.
Minute.
Yes. 56. 56, okay.
Then we can exchange our
pleadings.
Yes, pleadings. We can serve the copy of the same.
I don't know. 56 valid will be.
What is which is your item is 61.
61, your lordship, that my land.
Yes, 61 is also there.
61 is.
I think 56, my land, Mr. Das is there. That's a heavy matter.
Heavyweight
No, no,
heavy matter.
not heavy. That is, your lordship has directed me to obtain instruction with regard to that pension, whether it has been attached or not. Now, in the entire pleading, no such allegation that his pension account has been attached, all these things. However, we have already got the information that now the property has been already attached. And provision is that under section 8(2), that they will receive the notice from the adjudicating authority and they have to submit the reply. And that
Then
it can be modified.
let me argue, Malad.
There is no scope.
No,
that
it
is
will not take much time, Malad. It will not take much
Then
time.
it will take time.
Malad, it will take. I can convince your lordship, Malad. The argument which is being advanced, Malad, is with due respect.
Yes, Mr. Mishra, please wait. Let us see. Please wait.
With due respect, Malad, it is preposterous.
56, na?
56.
He put out
56.
Yes. Yes.
Malad, on the last occasion, Malad, the lordship wanted to know whether the pension amount has been, Malad, attached. Pension, Malad, provident fund, my wife's salary, my daughter's salary, which under no stretch of imagination can be said to be proceeds of the crime, Malad. My learned friend relied upon a judgment of the apex court. And the judgment he has shown only a part of the judgment. The judgment I'll show him from. Please.
No, there is no pleading. That is why I am saying.
Please, this is not a.
Without any pleading, how can I plead?
Pleading where?
In the petition. He has not alleged that my pension has been.
Malad, he has to first.
Here in this petition.
Malad, he has to read the brief first, Malad, then make a submission. Page 6. Please, page 16. Page 16, Malad, of IA 448, 447. Page 16, paragraph J. Besides, let's see what it, Malad. Besides, the above opposite party has illegally provisionally attached the pension account of the petitioner.
Para 6, huh?
J, my lord. Para 6J.
Yes.
Besides the above, the opposite party has illegally provisionally attached the pension amount of the account of petitioner that is maintained in the Axis Bank, Basughai Bank in item number 8 of the schedule of the movable assets. You know what? More, please.
Yes, yes. No, I have not received because
What not received, my lord? My lord, making a submission that I have not made an averment. Now, when I say give it to my lord,
IA. You are telling about the IA.
what is the pleading here? This is not a civil case.
What he says that IAs are not to be
Not to be seen.
That's
Not to be-
what. IA, he is making it very specific state. See, the only last time it was argued. The only thing is you have to seek instruction. You are supposed to seek instruction. Whether the pension account and the salary account of the children
Yes.
have been attached or not. Because this can't be the proceeds of the crime. So therefore, in the name of the PMLA, you can't attach the regular, salary obtained by the daughter of the accused and the pension.
I am giving reply, madam.
Please, I have not completed, please.
No, my lord has.
So let me
question, madam. Answer.
Well, let me.
Thing is that I have instruction. I have the instruction that he has not alleged that particular account is pension account. Number one. Yesterday he has filed a memo indicating several accounts number. And also,
no, your confiscation, your order, provisional confiscation order.
Now I have
you yourself have said that a pension.
Yes. So I have the instruction that already provisional order of attachment has already issued, and it now complaint petition is now under process. It will file by tomorrow, day after tomorrow. Now he will be given notice to have a say, and he can submit all the reply there. It can be adjudicated.
No, why, my lord?
Yes, let me say. Now the authority who was attached, he has no power now because rule says, section 8(2) says, immediately after provisional order of attachment, the matter will be sent to the
Adjudicated and all.
So now only recourse is that he has every right. I am reading with the provision.
Well, let me complete.
Yes,
before the case states that it's
8(2). Just a minute.
just going to move closer.
The appointing authority shall, after considering the reply.
I know you are sanctus officio now. I understand. The sanctus officio. Once provisional confiscation order is passed, it has to go to adjudicating authority. Adjudicating authority will give you an opportunity.
Yes.
To do
Now he submitted
that. This is the scheme of law.
Yes, nothing can direct the authority to consider all his objections.
Now, yes.
Malad, what they will be attaching, Malad? They can attach only the proceeds of the crime, nothing more. Malad, that is the one I want to show your lordship from that judgment which is cited on the last occasion. Malad, the judgment is 500 some odd pages, so I am not assisting your lordship by giving my tab to your lordship, Malad.
Which paragraph?
Malad,
This is the.
Malad, I just before lordship goes that, first Mr. Kapil Sibal argued in Article 20. Then Mr. Siddharth Luthra also argued in Article 20. Mr. Singhvi argued in Section 5. Mr. Mukul Rohtgi reiterated what Mr. Kapil Sibal and Mr. Singhvi argued.
Now, which paragraph you want?
Malad, now I will come to Malad.
Yes.
Malad, lordship kindly come to page
20.
231. It is the finding.
31.
From paragraph, it starts from paragraph 19.
Para 19, huh?
Yes.
Yes.
The act was enacted to address the urgent need to have a comprehensive legislation inter alia for preventing money laundering, attachment of proceeds of the crime, adjudication and confiscation thereof, including vesting of it in the central government, setting up of agencies and mechanism for coordinating measures for combating money laundering, and also to prosecute the persons indulging in the process of or activity connected with the proceeds of the crime.
Yes.
So the focus is on the not process of the crime. Then lordship kindly come to page 232.
232.
Yes. Malad, just before that introduction part, Malad, This is evident from the introduction and statements of objects and regions accompanying the bill, which became the 2002 Act.
32, na?
Yes, page 232, my lord.
Yes.
The same reads thus. Introduction. Money laundering poses a serious threat not only to the financial system.
Show me the ratio exactly.
I'll just take a look to the blood. Paragraph 30 at page 251.
251.
Milad, this judgment deals with each of the aspects separately, independently, Milad. Section 5, Section 8, then Milad, proceeds of the crime.
251 you tell.
Yes.
Para?
30.
30, okay.
The other relevant definition is the proceeds of the crime in Section 21U of the 2002 Act. This definition is common to all actions under the Act, namely attachment, adjudication, confiscation, being civil in nature, as well as prosecution or criminal action. On the last occasion, it was said as if it is only a civil action, my lord. The original provision prior to the amendment of the Finance Act 2015, I can skip over, my lord, 4 or 5 lines. Then why the Finance Act 2015? It is further included such property being proceeds of the crime, which is taken or held outside the country, then the property equivalent in value held within the country, and by further amendment by the Act 13 of 2018, it also added property which is abroad. By such amendment by the Finance Act so explanation has been added, which is obviously a clarificatory amendment. This is evident from the plain language of the inserted explanation itself. Then Lordship may kindly skip over, come to paragraph 31.
The proceeds of crime being the core.
Yes, core of the ingredients constituting the offense of money laundering. That expression needs to be construed strictly. In that, all properties recovered or attached by the investigating agency in connection with the criminal activity relating to a scheduled offense under the general law cannot be regarded as a proceeds of the crime. There may be cases where the property involved in the commission of the scheduled offense attached by the investigating agency dealing with the offense cannot be wholly or partly regarded as proceeds of the crime within the meaning of Section 21U of the 2002 Act, so long as the whole or some portion of the property.
Whether it is there is no straight jacket formula
exactly
laid down by the court.
Exactly, my lord.
Is that whether you have to attain a subjective satisfaction whether a particular thing is proceeds of crime or not.
It is not subjective, my lord. It's objective.
Oh, okay.
It is objective, my lord.
Objectively, somebody has to tell that yes, this is a proceeds of crime or this is not a proceeds of
yes.
crime. It says that only proceeds of crime has to be confiscated.
Yes, and Lordship in that page 253. 1, 2, 3, 4, 5, 6, 7, 8. 9th line from the top.
So long as the whole or some portion of the property has been derived or obtained by any person as a result of criminal activity relating to the stated schedule.
The next sentence. To be proceeds of the crime. Therefore, the property must be derived or obtained directly or indirectly as a result of criminal activity relating to a scheduled offense. Well, is my salary criminal? Is my something criminal activity?
I am inquiring.
Exactly, my lord. It's absolutely preposterous to say.
Salary, pension, all these things can't be.
How can this be, my lord?
Crime.
And my lord, the lordship will see their attachment order is based upon the FIR law by the Vigilance Department. There is no independent application of mine. Whatever I had submitted and furnished after getting a notice under Section 50, they have not considered the explanation. They have simply detoured what they got from the Vigilance Department. And law doesn't say so, Section, Lordship may kindly see Section 54.
Where is that confiscation order?
Well, confiscation order is that, it starts from page 26, my lord. Lordship may kindly see page 26.
Yes.
And before to page 26, my lord, Lordship may just see Section 54 of the PMLA, my lord. Let's just see section 54, my lord.
Why are we need not labor on that? Simply
That
fact
we
is,
are-
it is not a proceeds of crime.
Yes,
It has to be seen whether it is a proceeds of crime.
exactly, my lord. And
If a proceed of crime, then confiscate.
Yes.
Or what he says is now the authority under the provision has obtained an objective satisfaction that is a proceeds of crime.
Yes.
Right, whatever. And there is a process. That is the reason the adjudicating process is there.
my lord,
Notice will be given to you and go and explain.
my lord, the entire action is a nullity. To attach my, my lord, pension amount and salary is a nullity. Act doesn't prescribe that. If the,
How will you separate the
well, that is what I have, that is what, not in my memo, I had categorically stated, my
what
lord.
are the you
Yes.
separate them?
Yes, I have given, my lord.
What is that?
I have given the memo, my lord.
What is that? You have to separate everything.
Well, I have given, my lord.
That exercise this
See,
court can't keep
they-
on doing.
yes.
That is the reason there is a procedure given.
My lord, procedure given. Lordship may kindly say, my lord, they can.
So show me which are apparent. Show me. I will remove those things.
Yes.
Show me. You have filed the entire thing.
No, I have given not entire, my lord. Lordship just sees the, my lord, memorandum. These are only the salary account. All this account is given.
You give not that then a complete.
No,
I am entering to the arena of adjudication.
No, my lord, no. Lordship may just sees the memorandum. If a lordship takes away the documents which are filed to support, my lord, the memorandum.
Savings account number so and so Axis Bank.
Yes.
Savings account is salary account or
Well,
not?
my lord, that is
Pension account of the petitioner.
my lord, that is what I mentioned, my lord.
Okay, pension account.
Yes.
Savings account number so and so appearing in serial number 16 of schedule.
It is salary of my wife.
Salary account of
My wife, my lord.
so and so. And except salary, nothing is deposited.
My lord, here nothing else, my lord. It's only salary account.
It's subject to expense, sir.
But it's subject to
एक मिनट.
that they have to
savings account number HDFC Bank serial number
28.
28.
Yes.
The
Salary account my daughter.
Fixed deposit in the name of petitioner appearing. A fixed deposit can't.
My lord, these fixed deposits are from my lord, PF, my lord.
How will I adjudicate
My lord, that they should they not investigate that, inquire that.
That is the reason adjudicating.
No, they have to make an inquiry.
Fixed deposit of so and so. Fixed
So-
deposit can't be. I
What?
can't. I don't know where from that source.
Lordship
It may be self proceeds.
Well, let this 4 and 5 be left open, my lord. 1, 2, 3.
This salary account, you have to make a statement at the bar that the two account number 2 and 3 salary account of your daughters.
Yes.
That is Sangamitra and Arpita.
Yes.
This is a pure and simple salary account, and the deposits are only from salary.
Well, that is
You
what
make
I-
that statement. I will take it out.
Well, Miller, that is what I am stated in the memorandum.
Then I'll take it out. These three things.
Sorry, Miller?
I'll take out these 3 accounts from the.
Yes.
From this case.
That's this 3
That
accounts.
is
Miller.
my lord. Once I
Correct.
give you an example. Suppose for 1 year, he has earned from any source of service, but he has not expended single pie. So that is a procedure of crime.
No, but pension account.
Because he has
pension account.
But now that is why 82 says that the adjudicating authority shall, after considering the reply, if any, to the notice issued under subsection 1 authorized by him in this map, shall consider and by an order record a finding whether all
What
any of
I'll do is I'll say that subject to the verification by adjudicating authority within 15 days, these 3 accounts has to be released.
Yes. But now thing is the complaint petition is to submitted.
You file it. You can't
Yes,
say
yes.
you can't attach the salary account of somebody and you say
Yes.
that I'll make.
Agreed,
And, so far as the other properties are concerned, you take your own time.
Yes.
But these 3 account at least you release.
Exactly.
Because they'll survival.
Yes, my dear Lord. He will submit reply in respect of all the properties.
All property
And also
given
you
to
will
whatever.
also-
But in so far as these 3 properties are concerned, subject to verification by the adjudicating authority, within 15 days,
From
you
the date
release
of-
these 3 things.
From the date of receipt of the complaint.
Receipt of the content. I contempt. I will record your statement that you are filing the complaint within 2 days.
Oh, yes.
It is ready?
Yes.
You file it. In so far as these 3 accounts are concerned, you just verify and
He will
release it.
submit an application there.
He will do
Yes,
it.
yes.
He will do it. And in so far as the others are concerned, You take your own time, whatever time you have.
My lord, it is like, my lord, filing a writ application before the civil court. And civil court issues notice. And then one will say you have to.
I think I can do this much. This is the best thing I can.
Correct, my lord. But I am answering to what he is saying. That is preposterous.
Anyway,
Something plucking from the sky which is not available.
the petitioner is challenging the provisional confiscation order dated
No, madam.
23.
Provisional.
23 to 2024, my lord.
23 to 24. 24. The which is the officer? Where is that? Or where is that?
Order, my lord.
Order is 26. No?
Yes, 26, my lord.
26. 26. 26.
It's the deputy director, enforcement
Where-
director.
Deputy director?
Yes.
The pigeons are terrible. Okay. 26. Do you have any problem in pagination? It is not 26. 26, your petition runs to 44 pages. Your petition runs to 44 pages.
That is the lordship is looking at IA, my lord. In IA, my lord, IA 447, 487, my lord, I have page 26. I'm sorry, I have wrong communication.
That's right.
Wrong communication.
Okay. 26. Okay. Right. The provisional confiscation order was passed, has been passed on 23 to 2024 by the, who is that man?
My lord, Prasanna Kumar Naik, deputy director, enforcement.
Deputy director.
Enforcement directorate.
Enforcement director. Inter alia attaching provisionally attaching movable assets of the petitioner. Mr. Das, then counsel for petition submits that along with the attachment of all these movable properties, the competent authority has also attached the first tilda. Therefore, he says that the pension account of the petitioner and salary account of the daughters of the petitioner in no stretch of imagination.
And wife also. Daughters and wife.
Daughter and wife could be treated to be the proceeds of crime. Proceeds of crime. Therefore, the attachment of these three accounts besides the other is not tenable under law. Not tenable under law. Mr. Naik, appearing for the enforcement director, submits that after the provisional confiscation order under
Provisional attachment order.
Provisional attachment order, confiscation attachment order, order under section 8(2) of the PMLA Act, complaint would be filed before the adjudicating authority, and the adjudicating authority shall evaluate the attachment order, and by giving opportunity to the petitioners, and he further submits that the complaint would be filed before the adjudicating authority within 2 days. In the event the complaint is filed before the competent authority, the competent authority is directed to examine the three accounts which are enumerated herein above to ascertain as to whether these accounts are pension account of the petitioner and salary account of the daughter of the petitioner, daughter and wife of the petitioner, or not, and accordingly pass the appropriate order insofar as these three accounts are. in so far as the same exercise shall be done within 15 days from the date of filing of the
And you have so cause by the petitioner.
filing of the so
I'm sorry, my lord, the 2 days, if at all is given, my lord, he says, that will cross 30 days.
Which one?
Yes, yes.
Lord, 23-2 is the order of attachment. If 2 more days is given, it will cross 30 days.
Then what happened?
But it has
It
to
ended to your benefit.
But
Yes.
It's ended to your benefit. Why are you forcing him to do?
why
Let him do 20 days. How does it make difference?
if that gets recorded, blood,
He 2 days no likhi do in due course.
yes,
In due course.
yes, exactly.
Due course. So whatever benefit any to any
Exactly. Then I agree. I agree, my lord. Yes.
15 days from the date of filing, 15 days from the date of filing the show cause by the petitioner. In so far as the petitioners are given liberty to file separate show cause in so far as the three account aforementioned 3 accounts concerned. Separate show cause you file in so far as these 3 accounts are concerned. In so far as the other account concerned, you file further separate. I segregated basically. The adjudicating proceeding I have segregated. What is for 15 days, he will decide. What the other things, he will decide it is according to law. But at least these 3 accounts will be released.
And the main petition may lie over, my lord.
Main petition, nothing survives.
Yes, I have applied for quashing, my lord. The main petition may lie over, my lord. This,
After adjudication, appeal provides.
no, no, I'll satisfy lordship on that aspect also. It's not maintainable.
Now the proceeding has gone to adjudication.
Then what I'll do is, I'll give you liberty to raise all these points at the appropriate stage.
Lordship, hear me on the merit, my lord, because I can satisfy lordship.
Adjudication proceeding as well as the quashing, both can't go together.
But it can, my lord. It can. Lordship may kindly remember, my lord.
You have appeal remedy.
Well, only a weeks back, my lord, it has been quashed by the Supreme Court with regard to my lord, the Deputy Chief Minister of Karnataka. It was on this issue, my lord. It is the entire proceeding is vitiated.
That is also arising out of appeal proceeding.
Sorry, my lord. No, not after appeal, my lord.
Yes, appeal.
My lord, that is.
He suffered adjudication, filed appeal was dismissed, went to Supreme Court and SLP, leave granted, and thereafter.
But the Karnataka High Court rejected, then went to Supreme Court.
Yes.
Supreme Court allowed, my lord.
Arising out of appeal proceeding.
It's not appeal, my lord. Directly, my lord. Challenging the proceeding, my lord. The proceeding was challenged, my lord.
Maybe you are correct, but that's the procedure.
Now I am challenging
it. Now,
what? Nothing survives.
Now,
either you argue or I argue.
Adjourn it. So far as the main matter is concerned, adjourn.
Yes.
Keep it so.
Well, either I argue or he argues. This is not done.
Anyway, I am adjourning it. Dispose of the application is disposed of. Main matter is there.
Yes.
61.
well, adjudicating that is now in the session the matter. So what is the purpose of my?
Then
at the end you will tell.
Now things that the order going to be passed, that is available to tribunal.
I know that's yes.
The ODI Dhagata mu kahi pe open court re.
No notice in this case. No proceeding is now. He is to consider his case.
Okay, it's all right.
61.
May I please, your lordship?
Yes.
This is praying for question. ना एटा टी पद खाली कहबी दे चारटा खाली दी पेज प्लेस करबी आ बुझ करबी जो लॉर्डशिप विल डिसाइड आपण कहबे आपण दिन सारा कोन मु 10 मिनिट रो अधिक कहबी application for passing of order taking cognizance of offense ସରିଯିବ ଆଜ୍ଞା କାଇଁ ଆଉ ହଇରାଣ କରୁଛନ୍ତି ଗୋଟେ ଆଜ୍ଞା ମୁଁ ଗୋଟେ ଫିସ୍ ମିଳୁନି ଆଜ୍ଞା ମୁଁ କେତେଟା ଡେଟ୍ରେ ଅଛି ଆପଣ
Mr. Mishra, I will fix it tomorrow at 3 o'clock. Tomorrow 3 o'clock.
As your lordship please.
Because see it's 4 o'clock. If
my learned friend is hinting at that only. Online ne thili ma achi na thandi gharu.
But you gave the privilege to all of us to see you.
ଆଉ କିଛି କାମ ହେଇଥାନ୍ତା।
ନାଇଁ କାଲି ହବ
କାଲି
None, my lord.
Aaj
Your
one
lordship
part-
is adjourning for tomorrow. I have nothing to say, my lord. I am
that's the
obliged.
best thing. Do you have an objection?
No,
No,
Hey, he was
sir,
always.
he's there, he's there.
Sir,
Yeah, because he was
I
not
thought
there
you
in
were
the
not-
past over.
I have been waiting from since 1.5 hours. So I just came after being passed over because the bail matter was there.
I've seen what to do,
clashed.
what to do, 75 matters.
Your lordship can, your
And
lordship
many
can-
time, many cases are unnecessary.
Again, 482 anxiety, your lordship can appreciate, we have got nothing to say. This anxiety is something over anxiety.
All right, tomorrow 3 o'clock.
No.
And let
But
us have
the-
the privilege of hearing both of you.
But if both of them say, again it is like because he has not received the complete check.
It's there in the record, my lord.
No, it's,
My lord,
is
it's there. He will decide. He will just supplement the information. That's all.
Neither the call details nor the
Why your lordship will decide
nor
whatever is there.
this is the whole problem, your lordship. This is the whole problem with him. I don't know who considered him to be the what he packed. Is it the way my lord said? I have been submitting to your lordship. Is it the way to overlap?
Let him finish. No, I will reply. No, my lord, let him finish. I will reply. This is not the way. He should mind his language. He cannot just take anything for granted. Your lordship heard what he said. This is very unfortunate. Why he is behaving like this?
Senior should behave proper. We expect that. That's the only.
But
No
very
personal
unfortunate.
aspiration. You are doing your job. He is doing his job.
It's very unfortunate.
One sentence.
It's very easy showing it to the client.
Have I crossed my limit? The whole point is that when your
He has
lordship
crossed
said I
the
was
limit
going,
twice.
when both the
Not
people,
once.
no, I have not crossed.
Don't behave like that. There is certain limit to everything.
Are your language deserves
My lord, may kindly see. He is before honorable court. He is saying, "Are you?" Your lordship, see the language. With disrespect to the court. He doesn't understand. He doesn't have this basic understanding. And the imprimatur may be extended, man.
I